With the lordship's leave, my lord, I'm mentioning item number.
Today don't mention. Today is not the mentioning day. Yes, call the list.
Yes, purpose matter, my lord.
We shall take it up. Okay. Item number 2. Correction. Yes, call the next matter.
If your lordship fixes the habeas corpus matter,
We will take it up. Yes, next item.
my lord, I am appearing on behalf of the respondent writ petitioners, my lord.
Respondent writ petitioner.
Yes, in this matter, my lord, state is the appellant, my lord. In this matter, on the last occasion, my lord, we have submitted that against the, my lord, contempt rule, the state has, the principal secretary of the transport department has filed an SLP before the Supreme Court, and that proceeding has been stayed for the time being. And tentative date is 28th April.
28th April.
So far, the main matter is concerned, Supreme Court has not touched, but your lordship's view was, as because the Supreme Court is the session of the matter, if Supreme Court takes some observation that will affect both the parties, that's why your lordship was pleased to adjourn the matter on the last occasion. In this matter, my lord, the learned single judge was pleased to direct the respondent company to regularize the service of the two employees, but they did not do so. Thereafter, the court was pleased to issue complaint.
It is on 28th
April.
28th April.
Tentative date, my lord. Because after Holi, my lord, the matter was not taken up.
So we keep it on 8th of May. In the meantime, if it is done. We are not recording anything. 8th, you remind us. Yes, next.
Item 4, my lord. There is a delay up to 32 days, my lord, to file this appeal, my lord. And my lord, my learned friend has
my lord, as I oppose it, so first I will explain my evidence in opposition, why I oppose, then what is their reply, and then what law says.
There is a court procedure.
Sir, my lord.
You are not aware of that. You are the respondent here. So first right of audience is of the appellants.
All right, my lord.
You will get your chance. Yes, where is your reply?
Paragraph.
Reply you have given copy.
Yes.
Reply.
May I file our reply? It has been served already.
Yesterday, my lord, I received it.
It has been affirmed.
You are ready?
That's why.
Yes, yes.
Yes.
So there is a delay up to 32 days, my lord. If lordship takes our section 5 application, We
How
start with
long is the delay?
232 days, my lord.
232.
Loss of 2000. 32 days delay, my lord, only. And my lord, we have explained, my lord, in paragraph, starts with paragraph 3, my lord.
Now, first tell us what was the main order.
Main order.
Main order, my lord.
application আচ্ছা মেইন অর্ডার এখানে মানে মেইন অর্ডারে বলে তো যে সেটা
In the main order, my lord, that has been annexed with this.
এখানে সেকশন 5 এও
My lord, section 5 also we have annexed, my lord. If his lordship comes to
30
page 13, the penultimate page, my lord, lordship will find paragraph 17.
Yes, section 5. What is the reason?
My lord,
Which
yes,
paragraph?
Section 5 starts with paragraph 3, my lord.
You have filed any review application file?
No, he filed a review application during the pendency. And that review application for modification and correction, he has filed a review after this main order
Before the single judge?
with the single judge.
Yes.
In the month of August, my lord, that has been filed, and in the December, my lord, that has been disposed of.
Disposed of.
Lordship. Certain corrections has been made, my lord. That correction has been done, my lord. Now, my lord, in January, my lord, we have filed our section 5 application. Everything has been stated in our
Show us what.
Lord, kindly see, my lord, paragraph 3, my lord. 230 and finally, after having knowledge of this said order, placed the file before the Department of Finance, my lord, as usually, my lord, challenging the order dated 21st, and subsequently the file was sent to the LR for filing of the appeal against this one. Learned West Bengal so dated 11 approved the proposal for filing of the appeal and accordingly engaged learned advocate for preferring this appeal. That admits the above mentioned process, the petitioner filed a review application being review number so to point out a typographical mistake in the judgment dated 21/5/2024, and the order for such a review was passed in 3/12/2024.
Did you contest the review? Did you appear in the review?
It's a merely modification of a date, my lord.
That was served upon you.
That was
Yes, my lord, served and government advocate presented over there.
Now, my lord, thereafter, the learned so issued letter of engagement in favor of so said advocate dated 5/12/24 requesting her to take necessary action for preparation and filing of the appeal. That the learned advocate obtaining this order copy and the subsequent period of this date was utilized by this learned advocate for obtaining the order necessary documents in connection with this so. Your applicant states that there is an unintentional delay of almost 232 days in
So
filing.
when did you apply for certified copy?
in the month of January.
My lord, that was in the month of January.
That you have not stated.
That has not been, my lord.
My lord, 26 January.
We will release the matter, sir. We have told you at the first inception, we will call upon you.
রিপ্লাইতে মেনশন করেছে যে we have applied in January. Prior to that, we have
No,
mentioned the matter filed without certified copy, but it was not allowed. No, reply পাঠানো।
Actually,
Yes. This is your
Now, and so far, what has fallen from his lordship, my lord, in our reply, my lord, if his lordship takes our reply once, my lord, paragraph 4D,
no what to the opposition which was filed.
lordship. In 4E, my lord, we have mentioned that it is also stated that the appellants had in fact attempted to mention the matter before the Honorable Division Bench presided over by Honorable Chief Justice sometime in January 25, praying for leave to file memorandum of appeal against the judgment and order dated 21/5 passed in connection with the WPS so and so. Although certified copy of the order was already applied for. However, as the certified copy of the judgment was yet not available with the appellants at that
Which
stage,
paragraph you are reading?
paragraph E, lordship, 4E, page 5.
Reply.
Page 5 in our reply, madam.
এখানটাও দেখো, 116 দিন শুধু। কি আমাদের wait করতে হয়েছে? 116 দিন। এর আগে
You,
And in
you
4D,
were-
my lord, in 4D, lordship, kindly see
no,
the
that's
last
you were engaged in your opposition. You have said
engaged
November.
November, my lord.
December.
No, no, fifth
in
December.
November,
Lordship,
and you applied for certified copy on
in January.
in January.
During because of the reason, my lord, the review is pending. In paragraph D, my lord, if your lordship takes paragraph D's last portion, abundant caution waited for outcome of the review to ensure that the appeal can be processed properly, thereby avoiding any procedural infirmity and inconsistency. This alone accounts for a significant portion of delay from 9/8/2024 to 3/12/24.
Which paragraph you are reading?
Paragraph D, lord.
Just prior paragraph.
Just prior paragraph. Furthermore, the respondent himself filed a review application instead of a rectification modification application on so and so, seeking rectification modification of a typographical error in the judgment dated 21/5/2024 with paragraph 17 instead of that. This application was disposed of only on 3/12/2024. The applicants, out of abundant caution, waited for outcome of this review to ensure that the appeal can be processed properly, thereby avoiding any procedural infirmity and inconsistency. This alone accounts for a significant portion of delay from 9/8 to 3/12/24, that is 116 days, which is purely on account of respondent herein. Since pendency of the aforesaid review application before the Honorable Court necessitated to pause the appellant's action. And because of the file is not available, the file is with the review application. So, my lord, our application cannot be processed. And we have tried to, my lord, mention the matter before the Honorable the Chief Justice for grant us leave to file this memo of appeal without certified copy, but that has been declined. That has also been mentioned in paragraph E, my lord.
We have not
So,
wasted.
the allegation is that we have unnecessarily wasted time just to delay his contempt notice and all. And most importantly, in his opposition, my lord, he says, my lord, that there is no document has been filed with this section 5 application that the LR has engaged us and the inter office memo of the government, my lord. It's a purely a, my lord, confidential document of the government, my lord. He says, my lord, no document has been filed with the section 5 application with regard to the fact that finance department has processed with the matter and thereafter sent it to the LR department. This is absolutely, my lord, internal documents, my lord, and he has mentioned in his opposition, my lord, that no document has been filed.
21/2025 এখানে সাইন করা আছে না 22 তারিখে
And my lord, after getting the certified copy on 21st January 25, we filed this memo of appeal of 22nd January 2025.
করার 5 দিনের মাথায় পেয়ে গেছে।
Yes,
Lordship.
yes.
My lord, my humble submission is the contention of the appellant is totally incorrect, contradictory, and a deliberate attempt to mislead the honorable court. My lord, kindly take my opposition.
Yeah, just one more.
my lord.
Yes,
My lord, my opposition, my lord.
yes.
In my opposition, uh, my lord, the order impugned was passed in 21st May 2024. Then I have submitted one RTI application through online on 15th November 2024. 15th November. And the file was sent to LR, approved by LR on 26th November. So after,
Where have you stated that?
my lord, in paragraph page 3, paragraph 2, 3, my lord, paragraph 3(1), on 15th November 2024 at about 8:30 a.m., that is after 5 months and 25 days of the pronouncement of the judgment on 21st May 2024 in such and such, through West Bengal online RTI portal, I have filed an application under RTI to know the present status of my letter such and such. And I have also annexed
What
the,
was your letter?
my lord,
What was your letter of 27th?
27th, my lord, I have requested them to implement the order.
I see.
And my lord, after getting the RTI, my submission is, after getting the RTI, they have processed the file, and then on 26th of November, that is after 11 days of my RTI, the LR has approved the file. This is first. So before that, they were sitting idle. And regarding my lord, the review, that they are saying that as I filed the review, so they were waiting for the outcome of the review. Now, my lord, let me take out their reply in my opposition. Just a minute, my lord. Yes. My lord, in D,
Yes.
my lord, in their reply, page number 4, paragraph D, they have himself stated, furthermore, the respondent himself filed a review application instead of rectification modification application on 9th of August 2024, seeking rectification modification of a typographical error in the judgment dated 21st May 2024. First of all, I have requested for rectification, but Honorable Single Judge advised me to file review because the date has to be changed. And then, my lord, they have categorically told, wherein paragraph 17 erroneously mentioned 1st of March 2011 instead of 20th March 2012. So whether, my lord, this change, I have filed review for 1st March 2011 and 20th March 12. So,
9th August 24.
my lord,
9th paragraph D of their reply,
my lord,
review application, modification application was filed on 9th August.
No, review application, my lord.
That was filed later, no? You
Yes.
said that first rectification application.
First I mentioned, my lord,
Hmm.
then it was listed for correction.
Instead, please read paragraph D of their reply.
Yes, my lord. Instead of a rectification modification application. So they are saying I filed a review application on 9th of August 2024.
Yes.
So it's okay, my lord. What I am saying that through the review, I have requested to correct one date.
When was it disposed of? Your review, when was it disposed of?
Review was disposed of on 3rd of December 2024. Now, my lord, my humble submission is that review, there is two options. Review may allow, review may not allow. It will not change significantly because only one date has to be changed. For that, they should not wait till outcome of the review. And furthermore, my lord, my review has been decided on 3rd of December.
এই মাইকটা সরিয়ে নাও তো ওনার থেকে।
My
Yes.
lord, my review was decided on 3rd of December.
3rd of December. Yes.
3rd of December. And they are saying that they are waited till outcome of the review. But before that, they sent the file to LR for approval and LR approved. So their contention that they are waiting for outcome of my review is incorrect. And my lord, paragraph E, they are saying that they have after they applied for certified copy of the judgment, they mentioned it before the Honorable Chief Justice,
Yes.
which was turned down. So, my lord, in their memo of appeal, it is mentioned in the judgment last page that they have applied for Xerox certified copy on 16th January and date of delivery is 21st January. So it is obvious that they have mentioned it after 26th and before 21st. And they have submitted, they have filed the memo of appeal on 22nd. So is there any change? Is there there is no significant time lapse for this? They applied for and for, most interestingly, my lord, I have submitted, I have sent them contempt notice on 15th January. And on 16th January, they have applied for the certified copy. First, when I submitted RTI, they have sent the file, then they kept ideal. Then when I sent contempt notice, they have filed the application for certified copy.
What is the, Mr. Das, what is the, if sufficient cause is given, court interferes in section 5.
My lord,
Today, you have been passed a favorable order.
my lord,
Your order has not been stayed.
my lord.
So if on the ground of this is on the broader aspect of the matter. Today, if the section 5 is dismissed, then that will lead to further proceedings. Will it be beneficial to you, Mr. Das? Suppose today we pass an order in our favor, rejecting their section 5. Then what becomes? You can contempt proceeding, you can continue. But this dismissal on section 5 for a delay of 232 may lead to further litigations.
My lord,
May lead, kindly try to appreciate. Suppose today we dismiss the section 5 on the ground that the delay has not been properly explained, indicating your grievances also that there was a deliberate attempt on their part. Because after the contempt notice was served, they applied for certificate. But this dispute will again lead to further proceedings. Your ultimate hearing on the appeal will be deferred.
My lord, in either case, my lord,
Moreover, it has to be government department. Supreme Court has commented that since you are the state, you cannot take a plea that the file is roaming about from
Yes,
one
my lord.
department to another department. And in some cases, Supreme Court has intervened to the effect that it does take some time towards moving of the file.
My lord, I appreciate it, my lord.
So if you can show to us that there was a malafide, they want to deprive you. This Section 5 application has been filed with a malafide intent. They have a right to appeal. Once an order has been passed, they have a right to appeal. So in this context, what will be your argument?
My lord, in this context, my humble submission is that Section 5 is a discretionary power of the Honorable Court.
Right.
The court can do it out of exception. And for that, three conditions according to my understanding, my lord. First, sufficient or reasonable cause has to be shown. Then, whether it was bona fide or malafide. And then the last one, whether it for the substantive judgment justice or not, whether it will give proper justice to the appellant or not. So, my lord, here my submission is that they have not explained and shown the sufficient cause. They have deliberately adopted dilatory tactics, and it is not at all given them substantive justice. Because, my lord, I just wanted to check their opposition. They told that it will irreparably affect the government because of financial implication. My lord, the last budget was 3.4 lakh crore, West Bengal government.
Where did they say that?
No, I have the document, my lord.
Document of what?
The budget document.
No. Where did they say that?
Oh,
If you have-
what did they say, my lord? In their reply, my lord, just.
Time para 10.
My lord, paragraph B, my lord. Page 4, paragraph B.
The parties before the learned single judge that was exchanged. Have you filed any stay application in this?
Yes, my lord.
Huh?
Yes. We have filed a stay application.
Can two, my lord.
Can do.
Can do. In that you have annexed the pleadings.
Whatever document is, yes, my lord.
Have they annexed the pleadings?
Yes, my lord.
Eh,
The main writ petition along with the two affidavit.
that has been annexed in
Yes,
the-
my lord.
You are sure?
Yes, my lord. I have seen.
Affidavit in reply, page 49. Then, my lord, affidavit in opposition, page 42, and my lord, rest other petitions.
They have said that which has raised significant legal and financial implications. So, my lord, the state budget for 25 to 26 is 3.4 lakh crore. And if my lord allow the deny their appeal and grant me the pension, then I will be getting 14,000 per month. So per year, 1,48,000.
You were a lecturer in a college.
My lord,
You were serving as a in a college previously. Can you tell us the facts? What are the facts in the main matter?
yes, facts, my lord. I was appointed as confidential assistant to the Minister of Home Civil Defense, Government of West Bengal.
When?
In 2004, my lord.
All right. Then
Then in 2010, I resigned.
you resigned.
I resigned
Hmm.
and joined as primary teacher.
In 2010.
In 2010, my lord.
Yes.
You resigned on 4th of February 2011.
No, 4th of April, my lord, I have resigned from that post also, that primary teacher also, and then applied for pension.
So you joined as a primary teacher in 2010.
In 2010, my lord.
Then what happened?
After 9 months, I have resigned from that.
After that is in 2011 you have resigned.
I have resigned.
Resigned.
And the day after I have resigned,
Hmm.
I have applied for pension.
Pension for your service as a teacher.
No, I was not eligible for that, for CA, for confidential assistant. As I was eligible as per.
Just. So you, after resigning from primary teacher, you applied for promotion pertaining to your service as a confidential assistant.
My lord.
When did you make that? 2000?
2011, my lord.
2011 itself you mentioned you applied for pension.
My lord, on the next itself. And that time, my lord, the rule was there. And when I joined, the rule was there. When I applied, the rule was there. When I came before this honorable court, the rule was there.
Very good. Now the rule had been nullified. Now there is no such rule.
Now there is no such rule.
So did you challenge the order by which the rules were set aside?
No, when I applied, my lord,
Came previously.
yes, I have.
So during pendency, the rule was done away with.
When I applied, then the rule was there. So there is no option for challenging the order. I
Right,
have challenged the inaction of the government for not sanctioning me pension. And they have taken two contention, my lord, in single bench. One is the rule was withdrawn, and two, nobody is getting pension. But I have submitted, my lord, the name and treasury is everything of 5 ex-confidential assistants who are still getting pension. And I have also submit the bank statement updated.
That is in your writ petition records.
Yes, my lord.
You filed it there.
Yes, my lord.
In your affidavit in reply, you annex those.
Yes, my lord.
ঠিক আছে। Anything else, Mr. Das?
My lord, what I am saying, my lord,
We will condone the delay, because since it is a matter of policy decision, we will hear out your stay application and the main appeal, as all the records are here. We will make an attempt to dispose of your appeal finally.
my lord, you please, whatever my lord will decide, that you will definitely binding on me. But my lord, kindly record my submission.
Certainly we shall record your submission.
My lord, I just want to say that quote one judgment of Honorable Supreme Court. This is Office of the Chief Postmaster General and others versus Living Media India Limited and others. Judgment by P. Satyasivam and J. Chalameshwar. In that, my lord, they told in the absence of pluralism and acceptable explanation, we are posing a question why the delay is to be condoned mechanically merely because the government or a wing of the government is a party before us. Though we are conscious of the fact that in a matter of condonation of delay, when there was no gross negligence or deliberate inaction or lack of bona fide, a liberal concession has to be adopted in advance to advance substantial justice. We are of the view that in fact and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and inherent bureaucratic methodology of making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly bind everyone, including the government. In our view, it is the right time to inform all the government bodies, their agencies and instrumentalities that unless they have reasonable and acceptable explanation for the delay and there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending for several months, years, due to the considerable degree of procedural red tapeism in the process.
What was the delay there? What was the period of delay that matter?
400 something, my lord. 400 days. My lord, the Supreme Court categorically said that number of days is not a factor. The main factor, whether it is rational, whether it is bona fide, whether it is for to advance substantial judgment. In 3 aspects, this condemnation application is not cannot be approved, my lord.
Show us the judgment.
Yes, my lord.
সেটা কত নাম?
তুমি ভালো জানো আমার কাছে সব আছে।
My lord, in one judgment, there is some written, so kindly-
রিপোর্টেরটা কবে?
it is reported judgment, my lord.
বলুন না কবে সেটা বলুন।
বলে দিচ্ছি।
Which paragraph you were reading?
My lord, page number, I think, just a minute, where it goes, my. I think page number 29. Let me bring mine over. Yes. Page number 19 and 20, my. 2012 3 SCC 563. My lord, paragraph 12 and 13.
To represent application.
My lord, I have a few more judgment, my lord, where the Supreme Court categorically told that
You have not brought the recent judgment, sir.
But that's
You are handicapped.
I have not. Sir,
You
my
should bring the
understanding, but
judgments,
that
na?
such types of arguments will be made by one
So
another.
naturally, it is his right. He will not make.
But I have sorry. I'm extremely sorry for that. That I have not bring those judgment, recent judgment of Supreme Court, where the Supreme Court says, my lord, the delay may be condoned. Sufficient merits has been given.
So that is a very vague statement, Mr.
I,
Bosumali.
but
He is citing
apologize.
judgment. He has taken the trouble. If this is the casual approach on
No, not
behalf
the
of the
casual
state,
approach. Only thing,
that
but I have,
state appeal, it will be condoned.
no, my lord.
Then,
That is not that, my
so
lord.
then
But
we
I have,
reject it.
on merits, my lord, I have.
What is your answer to this? Tell us.
No,
What
but
is
there
your
are,
answer
but
to
there
this?
is Supreme Court ultimately, my lord, it says, my lord.
Or have you gone through this judgment,
No, my
Mr.
lord, I have just what he has fought
You are
as,
coming to argue a section 5 on behalf of the state in a
No,
very casual manner,
not casual, my
thinking
lord. Now, my
that
lord,
the state has committed delay, we will allow.
no, my lord, that I have not done that, my lord. So
So
far, this
that your
application,
action shows, Mr.
no, but the
Bosumali.
application is concerned, my lord. I have tried to explain each and every day's delay, my lord. It
What is
not
the
that,
substantive explanation? Explanation is my department was working on it. That has been
No,
deprecated in this judgment.
this period, my lord, this is a new fact, is my lord, 116 days. My lord, this 116 days delay, my lord, that application is still pending there in my lord. The main matter is
You take note of the judgment and what is your reply you give us? It is not a plate of cake for the government that
No, no,
whenever they come to High Court, the condonation delay has to be allowed.
I will definitely. I'm sorry, my lord, that I have not come prepared today, my lord, with the judgment. I'm extremely
Yes,
sorry.
what are your other judgments, sir?
my lord, in that Machi Senam versus Reddy Sridevi and ORS, Honorable Supreme Court Justice M.R. Shah has told,
That is subsequent to this. Subsequent to this judgment.
yes. So, in contrasting section 5, it is relevant to bear in mind two important considerations. The first consideration is that the expiration of the period of limitation prescribed for making an appeal gives rise to a right in favor of the decree holder to treat the decree as binding between the parties. In other words, when the period of limitation prescribed has expired, the decree holder has obtained a
No, that is in relation of private parties. This is government. This is
same case, my lord. What
you give the judgment upon which you are placing.
রিপোর্টেরটা বলুন জাজমেন্ট রিপোর্ট বলুন
21/9 SCR 476.
Mhm. Have you taken those
Yes,
citations?
I have.
Here Supreme Court said rendering substantial judgment is not cause prejudice to the opposite party.
All right.
Lordship.
When will you come back? We will keep it on that.
Lordship, fix a date.
You
in
tell us. You tell
a
us.
week's time.
In course of hearing. In course of hearing. It's got to take on চেম্বারে পাঠিয়ে উইকেন্ডে পাঠিয়ে আর কেউ পাঠিয়ে
But I appear for that. But I have served, but affidavit of service has not been done.
It is coming for the first time.
First time. Point of jurisdiction. Jurisdiction
Have
territorial.
you served? Have you served?
Yes, Lord, I have served.
Just interfere, my lord. My lord, on 30th April, I have a convocation at Maharashtra National Law University, Mumbai, my lord. So I have to attend on that. So any day except 30th, my lord.
You tell us. You tell us. You are coming from outside.
Yes, my lord.
You tell us.
He is coming regularly. to
No,
High Court,
no, no,
Lord.
what
He is
happened?
doing cases.
He's an
He is basically an advocate. Lord.
My lord, I have one pro bono case at court number 24.
When?
So, no, it was already over.
আরে ফার্স্ট মে করে দাও না। It will be there on second May একটা ফিক্স করা আছে না? Sixth May কি আছে? First
My lord, obviously.
first May.
Bombay
First
থেকে-
May. But first May is
No,
holiday.
High Court খোলা।
First May, my lord. No problem.
ছুটি আছে আমাদের?
No, no.
Yes.
Lord, territorial jurisdiction. For the first time, this is coming.
Have you served?
Yes, my lord, I have served.
Where is your affidavit of service?
Affidavit of service is not ready, my lord. That's why I'm.
Next week.
Much.
Yes. Next Wednesday.
My lord, I make refer to the appellant.
Hmm.
Lordship, praying for Passover because my senior is engaged in court number 26. Short Passover.
Next Wednesday. Yes. Yes. This for the appellant.
I forgot.
Have you served?
Yes, sir. That's appeal.
You are appearing.
But I appear for the respondent, my lord, led by Mr. Shomu Majumdar.
You are ready now.
My lord. My lord, he will be here, my lord, and because, my lord, we are suffering in this matter. The writ
You are?
petition- My lord, we are the writ petitioners. My lord,
Or
Today.
come tomorrow then. Not today. Yes. Ask him to be present tomorrow.
my lord, he will be here shortly, my lord. My lord, let my
You
learned
cannot
senior-
proceed on installments now. You will make some, then he will come.
It is only not to.
Yes, come tomorrow. Yes, next.
Ten million, I am for the state. Number two,
Yes.
I am for the state.
27.
Not to take the
27.
8 and
Seven. No, this is the
you are for
report.
the state.
I am for the state.
This for the
report,
petition.
my lord. এক কপি করে রিপোর্ট দেয় দেখ কপি রিপোর্ট দিলে
Who is for the petitioner, Mr.
কোনটা কল
No one appears on behalf of the petitioner to Mr. Mukherjee learned.
we are trying to trace the girl, we have some more time. Well, there is a report which says that we have will not kept no stone unturned, including
Item number 10, I am for the petitioner.
তাহলে দাও order telephone. Yes.
This is my affidavit of service.
pilot to the
Here, my lord, the girl of the petitioner is missing since 26 January 2025. Till now, no investigation has been made. He has not been recovered.
What is the age of the guy?
18.
You are the father.
Mother.
18 years. She
18.
has any sort of acquaintance with any other person.
My lord, that knowledge I don't have.
You must be knowing, right? It's your daughter.
Because I have specifically stated that in my complaint with regard to one person, he might know everything with regard to the manner missing of my daughter. But no steps have been taken. Kindly take my complaint that is at page 16. Complaint to the Malad SP Birbhum.
You did not lodge any complaint, no case
Yes,
has
before the
was
officer in charge, thereafter SDPO, thereafter SP, everybody, my lord, I have lodged a complaint.
Yes, what is your instruction?
Milord, he has alleged against one Supriyoda who appears to be, Milord, the cousin brother of the victim. Milord, the cousin brother of the victim is a suspect according to them. We have interrogated the cousin brother and the father of the uncle and the cousin brother. With nothing incriminating found from their statement, Milord. But we have taken help from the missing person, Bureau, Bhavani Bhavan, Lal Bazar and all that. Milord, I believe we require some more time, Milord, for recovery of the girl. Because she's 18, she left the house telling her mother that she is going to her maternal house. And the mother says that she was busy in a marriage ceremony where the
On
girl
20
was in touch with her. Suddenly, the mobile phone remained
switched off mobile
off.
on
Suddenly.
26,
But she
26,
was
my
in
lord,
touch with the daughter when she was in a marriage ceremony.
the mother was attending a marriage ceremony.
What
She was,
we will do, sir, in habeas corpus petition?
because we are, my lord,
Investigation
we
is
are, my lord,
proceeding.
lordship.
Investigation is proceeding. They have
But
interrogated.
they should expedite the investigation. 26 January, my lord, we have lodged the complaint. Since 26 January till the date of filing of the writ petition, no investigation has been done. After filing of the
Your
writ petition,
guard, you are accusing against a
I
particular
want
person.
I want my daughter to be find out. Nothing more, nothing else, my lord. Let them find out my daughter. Maybe, my lord, major, maybe an 18 years old, but he should be find out.
But kindly sees the fourth paragraph what we have done. Milord, the missing case submitted invitation to OC SOG to collect CPR, SPR, IABS searching of the missing person, but till date no fruitful result could be connected. My lord, we can kindly see annexure 3, Roman 3.
Whether she had been trafficked or not, your police
should have
authorities
been-
must be
that-
taking appropriate steps, Mr. Mukherjee.
Kidnapping, specific kidnapping against কিছু বলেনি. He is suspecting that
Well, our difficulty is, Milord, as your lordship knows, having vast experience better than me. Milord, cases can be registered when it is a non-cognizable offences. She has alleged missing. So, in the case of missing, Milord,
Where have you said that those two persons were interrogated?
Milord, in the report, Milord kindly sees that during inquiry, romancing.
What is your instruction? Is there any possibility? Your police authorities must be knowing what is the present status.
Present status is that we have called for the CDR, SDR, IMEI number, everything. But Milord, the problem is this: it's on the stage of inquiry because the allegation is of missing. Milord, she has never stated that kidnapped. Unless and until it is cognizable offence, we cannot draw up an FIR. Or non-cognizable offence, Milord, there cannot be any FIR, Milord. But even on inquiry, we have taken help of the missing person.
You have already registered an FIR.
No.
That is his statement.
No.
You have not yet registered
Missing
the FIR.
MP case number.
one MP case has been drawn up, my lord.
Then Ashok, Mr. Learned.
Since 26, the girl was missing. 27, the complaint was lodged. Today we are on 23rd April.
You lodged a missing diary,
Because
sir. You alleged against two persons. You did not file a complaint against them.
in
They
during
must be having
investigation,
something in their hand.
but
to
during
get-
investigation, let's kindly appreciate when during investigation, if they found something, they can turn
This
into
is
an
not a matter of course. Habeas corpus is a high prerogative.
lordship.
You will lodge a. You have not lodged a complaint. Simply a missing diary.
But I have specifically
And
stated,
moreover, the allegation, you simply a missing diary. There is no endeavor on your part also. That means that your mother is aware of something else, which you are not speaking out.
no, but that is not the fact.
So is it believable that my daughter will go missing some January and I will not lodge a complaint, though I know that he has gone with his cousin brother?
That
But-
specific instruction, we don't have that.
So if you
with whom
don't have, you have.
we have gone, we are
In that case,
suspecting
we
that,
cannot intervene.
we are
Missing
suspecting that
diary,
he,
they will be, so what they will do is missing diary. They will, next day, they will bring a photograph of the girl. And we are handicapped, sitting in habeas corpus. There is no appropriate step to that. We are simply adjourning the matter. কি করবো? formal complaint তো lodge করবে। See your allegation before the
that,
SP.
that I have,
প্রলোভন দেখিয়ে নিয়ে যায়, and you have not lodged a complaint.
See page 15.
Lordship, that I have seen, my lord.
Then
That's your complaint to the SDPO.
But they should, my lord, they should
what they
find
will
out the,
do? You have lodged a complaint. You have lodged only a missing diary. We are keeping it, next day you come with an updated report, then we will.
but may I get a copy of that report, my lord?
What
May
report?
I get a copy of the report filed by the state?
Is this? You have, why didn't you lodge complaint when this is your allegation against the police? SP representation. What is your explanation to that?
That-
Let us go to High Court. Let us file habeas
But
corpus.
we just want to, my lord, my daughter should be
Show us
found
the
out.
complaint where you have lodged.
We have lodged only a complaint that we could not trace out my daughter.
Then,
That is,
and come to page 15. What is your SDPO? Your allegation is?
আমি
You
মাঝে
are
ওর
aware of
বিভিন্ন
that.
বন্ধু
You
পরিচিত
know
মাঝে,
that. You have seen that.
Lordship, I have seen that Supriya Da is involved in the ballot.
Then it's Assume Mr.
And even if you have
Learned advocate appearing, a learned advocate appearing for the petitioner's We will dismiss your habeas corpus. Yes.
One intelligence serial number 9, my
Dismissal will you can go to there. সব জানে। Yes.
one intelligence serial number 9, my lord, I have missed, my lord, just now. Not to the
Contempt.
yes, my
The new matter. New
lord. No, not
contempt.
new. Second time, my lord. Not
Where were you?
just my lord, I am coming on another
Where
side.
is your other side?
Mr. Devopriyo Gupta is my other side, my lord.
If you get him, bring. Otherwise, we do. Yes, next.
Item 11, I am for the petitioner. My married daughter and her son, aged about 5 years, both went on missing since 19th January 2025. Her marriage was solemnized in 2018 with the respondent number 9. Her matrimonial abode was in the district of Howrah under Uluberia police station. Somehow, over telephonic message, we came to know that she is in the
Served upon the private response.
Yes. 9 is
You are the
father.
You are the
Father.
Jayanti Yadav is the wife.
Oh, mother. Sorry, I am the mother of the missing daughter of my
Since January 25.
19.
Huh?
Since January 19, she went on missing along with her son.
2019.
25. 19 January 25.
Along with her son.
Yes.
Then what? She's a married lady.
Married lady. I have made party to her husband. There was no matrimonial discord. But over what message I came to know subsequently that she grew up on relation in Facebook with one respondent number 9.
Who?
My daughter.
Your daughter entered into a relation with another person.
Respondent number 10. He is a man of Kandi, Murshidabad.
Then you lodged any complaint?
Yes.
Where? That has been registered?
No, missing diary was registered. So far, complaint part is concerned by postal, I have sent the complaint to the IC Uluberia police station as well as SP Rural Howrah.
Didn't go and lodge a formal complaint.
But that complaint was lodged under 156 clause 3.
The girl has already been recovered.
Recovered?
I have given the report. See the last 2 lines of the report.
I have no such instruction.
Kindly see the last 2 lines of the first page.
Wait to him.
No. মেয়েটা লিখেও দিয়েছে লাস্ট পেজ বাংলায় লিখে দিয়েছে
He made a declaration that he is staying over there.
of the report.
So this similar step you could have taken in the earlier one, Mr. Mukherjee. Tell your police to take that step. In the earlier one also, you can recover.
No, well, we have made all endeavor. We never say that we will not recover. I will talk to officer in charge. I will ask him to register a case on that matter. In this matter, we could work out.
So the present writ petition
Lordship, I am appearing for the state respondent led by Mr. Devobruta Chatterjee in this matter.
State.
Yes, my lord.
I am, Milord, I have filed an application for addition of party, Milord, I am for the wife.
Item number 12.
I have already filed an application for addition of party, I am for the wife, Milord. Against whom there are allegations of kidnapping her own
This
child.
is my application. Of course, Milord, I will submit first. But I am unfortunate husband.
No, he is a junior to you.
No, that is, but I do not want to say anything to him, my lord.
So we bring the application and hear it on the next day.
Application is already tagged. That is.
It has come before us.
That was not done.
Have you given copy to Mr.
Be allowed here and now.
Yes, yes.
Yes.
Let it be allowed here and now.
এসছে কি can application টা
In the
এসছে?
list it is showing reflected.
আচ্ছা yes Mr. Banerjee, yes, tell us what is the matter.
Yes, Lord, I'm unfortunate husband. Lord, for 10 years I was fortunate.
Pardon?
Lord, I am unfortunate husband. For
You are not unfortunate.
Lord, Lord, I'm telling you, Lordship, for 10 years I was happy. My two daughters, my Lord, marriage in 2013. Two daughters came out of the lawful wedlock of my wife.
Only 7 years.
My Lord, one is 7 years a girl, another is, my Lord, 5 years girl. Now, Lord, 7 years girl, my Lord, was admitted to Central English Medium Central Model School, Barakpur.
You are the father of
the child, of the two minor daughters.
Oh, you were married with whom?
Married with Maya Sahu, that is who has been added as a party.
Acha,
Applicant.
Maya
Sahu. In 2013.
Yes.
Lord, I was happy for 10 years. But then I came to know.
So when he came to you, he was unhappy.
Lord.
Yes.
Lord, then what happened when I came to know that she is involved with the Paramar, one Paramar, and my Lord, adulterous relationship with them, then my Lord started, Lord, quarrel between the husband and the wife. I wanted to get her peace, forget that man. Look here,
So
because two daughters are here. You are to look into the daughters, welfare of the daughters. Lord, I failed. Lord, ultimately, she left. Lord, in 8/2/2024, in her Paramar's house. Lord, the girl, two girl was with me. Girl was with me, and they, Lord, one girl, eldest girl, my Lord, was admitted to modern.
Two girls aged about?
Aged about 7 years.
Both of them are?
7 and 5.
7 and 5.
7 and 5.
5. Lord, if your Lordship look to page 20 and 21, the age certificate.
Lord, any matrimonial dispute is, any suit has been preferred, matrimonial suit?
Matrimonial suit has been filed by saying by wife, by saying that I have left the husband's house.
Now your daughters are with her.
Daughter with me.
Daughters are with you?
With me.
So why you have come with this?
Because on 8/2/2025, Lord, all on a sudden he came in the noon hours and Lord take away, kidnapped my daughters. And Lord, then we on inquiry came to know that he has also, Lord, entangled with the illegal activities, Lord, with that gentleman, Santosh. And Lord, I am apprehending that the girl may be sold elsewhere. And what, Lord, maybe there may be a dispute, maybe correct or incorrect, husband and wife. But what the damage is caused, my Lord, the elder daughter was studying in class 3. Lord, she could not be able to, Lord, sit in the annual examination.
So why you have come to us, Mr. Banerjee?
Because, Lord, I lodged a complaint. Because before that, Lord, I'm telling you, Lord, only 2 facts, Lord. Only 2 facts. Lord, class 3, eldest daughter, my lord, class 3, my lord, is studying. Then, my lord, she will have to appear, my lord, in the annual final examination.
Now, where are you residing? You are residing at Barakpur. And where is your wife residing?
Now, my lord, wife has said that wife is residing in Bihar. His only elder brother, her elder brother came and he affirmed an affidavit. He went there to make her understand. Go to your
Very
husband's
good,
house.
very good.
And he, Lord,
So you are wanting the
She is
custody of
residing-
the daughters.
she is residing, Lord, with the Paramar's house. And that Paramar is also having one wife and two child, Lord, male child. This is the whole difficulty, my Lord.
So you go and file guardianship application,
Lord,
Mr. Banerjee.
But my Lord, her, Lord, two daughters, Lord, they have been admitted by 42,000, Lord, paying, and their study has been stopped. Lord, for the best interest of the minor, my Lord, they are
What happened in the matrimonial suit?
matrimonial suit, my Lord. Just we came to know, my Lord, the service of the notice was given to me. We appeared and took, Lord, adjournment for the purpose of filing written statement.
She has filed a prayer for divorce. You are
Yes,
contesting
yes,
the
yes.
proceedings.
And he said 24 he went there.
So, Mr. Banerjee, the
Then
fit.
20 Lordship, kindly look to 8 to 24. He went there. Now, Lord, in Paramount house.
What direction you want from us?
Lord, I want direction exactly in accordance with the Supreme Court judgment. I may draw your Lordship kind attention 2 lines, my Lord, before your Lordship. Because the Lord minor's future, Lord, is required to be looked into. Paramount consideration is minor's
That we will ascertain.
welfare of the minor. Welfare of the minor. That is to be seen.
Parents' petri jurisdiction.
Yes,
why
parent patriarch jurisdiction.
Why
how
we
much
will exercise? The
Lord, that is why,
the
Lord, I
daughters
may
are
place
with the
before you, Lord.
mother.
That's right. Lord, this argument was advanced. Only two lines I can draw your Lordship kind attention.
Achha, let us ascertain from him what is the problem.
Lordship, an inquiry was made after getting a petition of this habeas corpus petition, and they are very much traceable. The girls are with the mother itself. What my learned senior counsel has not referred to, that there is an existing FIR against the husband under section 8535, which is pertinent to 498A.
I have referred in my petition.
498A of the Indian Penal Code, that is on 8th February 2025, that was lodged. After, while we were making inquiry of this habeas corpus petition, whether they have been illegally detained or not, it was found that the children are with the mother at an address in Khorda, and that was videographed, and the report is ready, and they have stated that they want to stay with their mother itself. This is the report, my lord.
Their education is suspended.
And very good.
Their education is suspended.
So, sir, we will add you as a party.
Yes.
We will add you as a party. You answer in your affidavit what steps you are taken for the education of the children, where you are now presently residing.
Yes, Milord, in Khorda, the wife was tremendously tortured by the husband. This is, Milord, the
After
written
10 years.
complaint. Kindly see, Milord, what is the in her written complaint.
That complaint I have annexed.
The last page of the written complaint.
Yes.
Now,
Because on 8 to
the being tortured by the husband,
You left the residence.
wife used to go to a temple.
Uh-huh.
Wife used to go to a temple. In such temple, she made a friend, a lady. Now on 8, what happened? That is the last page, Milord, the complaint on 8. What happened? Kindly see. And when she went to the Bihar to her brother refused to take any responsibility. So she had to come back to her friend's house, who is a lady. At present, she is staying with her lady friend at Khorda. And the written complaint, Milord, that is very much serious and grave in nature. Kindly see the last page. It is written in Bengali. On what happened on the very same day when the husband alleging that wife left the house.
So on that basis, you have initiated a case.
Yes, my lord. On 8th February, she herself
What
lodged.
are the sections you have given?
Lordship, only 498, that is under section 85.
The allegation is very serious.
My lord.
So why didn't you incorporate the other sections?
Lordship, still it is under investigation. That was the reason we didn't alter the charges right now.
Even after this complaint, it's prima facie satisfaction, sir. If this is the allegation, your police will not register appropriate sections, will not, so that you can take him in custody.
Lordship, I will
A cognizable offense. Now, what will you do with your children? You don't have money.
The husband is not paying any maintenance.
Exactly. So
In
what
the divorce-
will happen to the children, sir?
The divorce suit, my lord, she will file an application for interim alimony, and the friends, they are now taking after the wife and the children.
In blood for the welfare of the two children, I paid.
What welfare, Mr. Banerjee? You have very serious allegations. What welfare?
My answer would be before your lordship, in a habeas corpus petition, allegations, counter allegations cannot be looked into. Only my lord, welfare of the child is to be looked into, and they should be brought in. Their corpus should be brought in the court. I have brought the judgment of the Supreme Court on this, including the latest judgment. Let him come back. I shall have the copy to him. Lord, only this argument was advanced. Lord, may I read that line?
We
before
know
your
that,
lordship
Mr.
of the Supreme
Banerjee,
Court?
but the to
I
better
can
be
satisfy
cautious.
your lordship.
We have
Forget about husband-wife
no,
dispute.
how will he forget? A 7-year-old daughter will reside with his father, against whom such allegations are there.
Lord, the allegations, criminal allegations, Supreme Court said, there are also allegations are there. Supreme Court said we are not concerned with this, whether right or wrong. But we are concerned with regard to the
So
welfare of the child.
any possibility of
In a habeas
settlement, you
corpus
are not with any
Already
parameter.
suit for divorce is already there, my lord. And if the father is so much concerned, I am, my lord, providing the account number of the wife. Kindly direct him to pay monthly maintenance. And after that, the guardianship of the child may be settled before the ADJ under the Act.
Lord, your lordship reads the lordship knows what is happening in our society. That is I'm telling you, lordship. Every day, one or two incidents in the paper.
And the
Well,
13 I beg to appear for the petitioner. Petitioner is anxious of getting any information with regard to his son, minor son, who is aged of only 10 years. I tell your lordship,
they have been recovered, produced before the Child Welfare Committee.
Acha, let him submit.
The report of two police stations, Basdoni and Narendrapur.
the petitioner is having an acrimonious.
Are you aware of that?
I tell your lordship, we knew the child was initially living with the wife. He was admitted in an hostel in Paschim Medipur, from where he left the hostel, all alone came to Howrah station. He was recovered and was handed over to her maternal parents. It was informed to us. We are called upon the police authorities. We went to the police station.
Who are you?
I am the father.
Acha.
And since the police station, the child was taken, and I was told that he was being handed over to the CWC authorities. But I went to CWC authorities. I was not allowed to meet the child. Even the police authorities also failed to disclose where the child is, and I am roaming here and there, running a pillar post. I am not getting any news of my child. This is my allegation. I have lodged a complaint also, sent my complaint through mail also.
They are saying that he has been recovered. He is presently in the.
Well, 4 lines from the bottom of the first page.
It was not informed to us.
Police station. Gita in Boys Home, 33 Gitanjali Park, Calcutta 99, Kolkata 99.
It was not informed to us.
Your wife is a party here.
Well, it is.
You have served.
I have served him, but I feel that the service is not complete. It was returned with the address he moved on. The postal endorsement is address he moved on. But even if he is with the authorities of CWC, he must have a right to visit, and I should be informed.
No, for that we
No, I'm পুলিশ আমাকে তাও বলে
No, you have a strained matrimonial relationship. When did she left the matrimonial house?
in the year December 2022.
Very good. Thereafter, the dispute was the lady lodged a complaint against her father.
I tell you what happened, my lord.
No, that is what we have been shown. But now the child is in a particular home.
That we were not informed.
Go and meet with your child.
For the first time, my lord, we came to know. We are not been told. The child was.
In course of hearing, Mr. Mukherjee, learned advocate appearing for the state, submits that 14 কে আছে?
3 সপ্তাহ পর
You are there, Mr. Mukherjee?
yes রিপোর্ট ডেটা
এই কার্তিক
আমরা হরিয়ানা আছি।
পিটিশনার নট
এখন আমরা গতকালকে হরিয়ানা গেছি
অ্যারেস্ট করেছে
বাঁকড়া থেকে বাঁকড়াটা ডোমজুরের আন্ডারে
না এনি রিকভারি মেড?
No, my lord, it's on the process. We have arrested one from Makra under Domjul police station. Yesterday, the other team went at Haryana because the boy was found to be missing from Haryana. The private respondents took him. The child or the son of the petitioner was taken by the private respondent to Haryana for providing job. Thereafter, the boy was missing as has been alleged by the father. The father went, he could not he could not find the whereabouts of the son, came and lodged a complaint at Domjur police station. We have arrested one suspect from Domjur, and for the other suspects, since they were residing at Haryana, our team left for Haryana yesterday.
Oh, I see.
One was arrested, and for the other, since they were from Haryana, our team left yesterday.
in contact with the father from November.
No one appears on behalf of the petitioner. Stop Mr. Mukherjee and the advocate appearing for the state respondent submits
the origin, the original father is this one, but Urban is the that's in the report. I've missed it. That
The age is also
yes,
unnatural.
we believe we will be able to trace him out
So
because
my lord has read the brief more than you.
because on a specific tip off we went there. Yesterday our team had been to Haryana. I'm grateful. But may I only pray one thing?
Yeah.
May I only
কি বলছো?
But all our courses are in the veterinary building. Will it be pilot's pleasure to fix, my lord, habeas corpus in any one day, today at 2 p.m., 10:30 in any day?
Oh, I see. All right, we will consider. On second you appear, thereafter we. Yes, next.
But item number 16, my lord.
Yes.
But first, I tender my sincere apologies for appearing online, my lord. I'm indisposed, my lord. My lord, I'm for the appellant state, my lord. I'm led by Mr. Bondopadhyay. My lord, on the order dated 26th February, my lord, directed to file the paper books, my lord, informal paper books, my lord. That has been filed, my lord. My lord, kindly, can it be taken on next week, my lord?
Paper book you have taken?
Yes, my lord, I have to, your lordship kindly fix the matter at 2 p.m. in any day.
2 p.m. Mr. Banerjee, now
It
it is the first hearing.
It is very short matter, my lord. Your lordship kindly in any day, my at 2
p.m. it cannot be fixed. Yes, sir. It is fairly at the top. It will be reached. Yes, paper book near the. Yes,
informal paper book, my lord. Informal paper book. Paper book is here.
So come tomorrow.
My lord, can it be on a next week, my lord? That is what I have been asked, my lord, by Mr. Banerjee, my lord. Led by Mr. Banerjee, my lord.
The key order ছিল দেখি। ও কার হবে? Your appearance for union. Union.
Seven, 8, and 9.
That's it.
Repetition. তো এই তো পেপার বুক পেয়েছি ওরা পেয়ে গেছে বুককে মনে হয় ফাইল করে জিজ্ঞাসা করতে চেক আমরা তো আমরা পেয়েছি আমাদের পেয়েছি যে এক্সপ্লেনেশন কিন্তু পেপার বুকে এক্সকিউজ আমরা ওই দিনকে খবর নিয়ে
না সেটা যাই না দেখতে হবে। Ayush doctors.
Yes.
Oh. It will be on next Monday.
Monday, in place of Monday, when you logically take it on Tuesday, my lord.
Tuesday. We are not passing any order. Tuesday it will be there in the list. We are not passing. Tuesday.
Grateful, your lordships. Grateful.
Tuesday top.
টপেই তো আছে আর কত টপে My brother says it will be above our names. Yes, next.
My friends told me that you logically take it at 2 p.m.
Yes. Yes, 17.
And for the
My lord, 17 and 18, my lord, I'm praying for accommodation for 2 days.
You are praying for?
I'm for the, in one matter, my lord, I am for the respondent, in another matter, I am the appellant.
My lord, the same order was challenged by both the parties.
না এটা 17 হচ্ছে
Sorry, my lord.
Yes, who is opposing you? Who is opposing you? কোথায় পালিয়েছে?
My lord, in this matter, item number 17, I am appearing, my lord.
You're
I will 1 week time. I required 1 week time. After 1 week, my lord, due to some personal difficulty.
Lordship, I
Item
leave
number 17
or
for the respondent.
for the respondent, Lordship.
Let us hear Mr. Mojumdar.
Yes, Lordship.
Very well.
Let us hear Mr. Mojumdar.
Very well, my lord.
Huh? Yes, start. Did we hear it earlier, Mr. Mojumdar?
Yes.
Huh?
The bench presiding over my your lordship and the honorable Mr. Justice Partha Chatterjee.
Oh, আচ্ছা। এই কার্তিক দেখো তো নোট কোথায় রেখেছি দেখো তো নোট নিয়েছি দেখো তো। পার্থর সাথে শুনেছি বলছে এখানে এখানে নেই এখানে এখন বলছে পার্থর সাথে শুনেছি Yes, Mr. Mojumdar.
Excuse my lord. Fragmental proceeding dragging out of a charge sheet that's culminated with the order of dismissal from service. Petitioner preferred wrapping that appeal was dismissed. Now, my lord, petitioner moved the writ petition before the writ court. But, my lord, the writ court, my lord, summarily dismissed the writ petition of the petition. Now, my lord,
এই জয়ন্ত
first submission
এখান
to
থেকে
the lordship.
সূত্র যদি পাঠাও দুটো একটু পড়ে গেছে হ্যাঁ Ordered is at which page? Ordered impugned at which page? Oh, Sundip lock stock bearing in place. একবার আমার সাথে বসেছিল $268, yes. কিন্তু না কন্টেম্পটা শুনে নিলেই তো হতে পারে ইয়েস 260 নেই না ঠিক আছে So let us go through the order. Yes. We will just শেষ করে দেবো। Mr. Mojumdar, you won't be able to finish it. It cannot be finished today. We are at 1 o'clock. Cannot be finished today.
No,
Keep it on some other day.
Yes.
Keep it on some other day.
It will take on the last term, it was almost completed by 2 to 3 days, I think, submitted on the last occasion.
What can be done, sir? It cannot be done. Next Tuesday, রেখে দিও।
My lord, 1 week adjournment, please.
After tomorrow, I have to, my lord, complete my submission because
We are
I am
keeping
already
it on
completed my
Tuesday. Tuesday.
My lord, kindly keep it on Wednesday, my lord. Wednesday, my lord.
Let it be on when. What problem you have?
I will out of station, my lord.
Next Wednesday করে দাও। দিলে একটা password। কি password আছে? Contented কি password লিখে দাও। পুরো process।
গন্ডগোল হয়ে যাবে, ভালো করে বাঁধো।
একটু ওই দুটো কন্টেন্ট ডেকে দিন কে আছে।
89 for the respondent, Mr. Sonajit Ghosh is for the
Item 8.
18.
No, not 18. 18 is a password matter.
Sorry.
8 নেই কেউ। দেখি একটু 8টা দেখি কোনো অর্ডার হয়ে আছে কিনা দেখি। মনে হচ্ছে কমপ্লাই করে দিয়েছে সেই জন্য। আমাদের judgment সুপ্রিম কোর্ট Yes, Mr. Chatterjee, here, Mr. Orpo Chakraborty is appearing.
This matter is serial number 8.
Yes.
What it is?
वो जाने वो Orpo,
I will inform Malal, it will be not today.
I think the order has been complied with. They are not coming.
I will for this.
Must
I
have
will
been.
inform Malal, let it be sort, not today only, I will inform today.
For it to talk.
Yes, Malal, I am for the petition.
Malad, I am for this.
What, affidavits exchange?
Yes, everything is ready for my lord. Page 21, this is the my lord's order. Malal. Page 21, paragraph 17.
Yes,
I am
please.
reading, my lord. Page 21, paragraph 17, my lord. For the reason discussed above, the impugned order dated 31st August 2016 passed by the learned tribunal in way number such and such, as well as the order dated 1st September 2015 and 24 September 2014, impugned in the original application are set aside. And the respondents are directed to grant the first MSAP benefit with effect from 1st September 2008, as well as the third MSAP benefit to the petitioner counting his entire service prior to his promotion to the post of section engineer. For our first portion, they have complied with, my lord. The respondents are directed to grant the first MSAP benefit with effect from 1st September 2008. They have granted. They have been granted. I have no grievance, my lord. But I have a grievance, my lord, as well as the third MSAP benefit to the petitioner counting his entire service prior to his promotion to the post of section engineer. That I have, because they have not, they have deleted my lord, 1 year service from my entire service period. They are, I was sent to the training initial. That period they are not counted. But the MSCP circular says that was not the issue before the writ petition. That was not the issue before the original application. Now the new point they have been inducted in the after at a time of compliance, madam. Kindly see their compliance, madam. I am
No, first show us orders of 1st September 25 and 24th September 50,
that is
which
a
we
writ-
set
that is
aside.
writ petition. That is in the writ petition.
So in that they refer to about training.
No, there is no issue of training, madam. Now they have curtailed that training period of 1 year, but and I have been
So
giving.
your contention is under the MSCP scheme, the training period also needs to
Yes,
be
my
taken
lord.
into
MSCP circular said, my lord. First, my lord, kindly see the circular. 1 second, my lord. In read petition, my lord. Kindly see the read petition, my lord. The mother circular of the MSCP, my lord.
No, we will come to that. First, show us their order.
Order they have been annexing the, my lord, their affidavit, my lord.
এগুলো একটু বের করে দাও না affidavit in opposition reply also you have filed.
I reply file. Page 3, my lord, page 3, paragraph 4. They have
just a moment, let us get it. Our judgment was upheld by the Supreme
they
Court.
have stated, sir. Without any
Yes.
modification. Page 3, my lord, paragraph 4 of their affidavit, my lord.
Wait সাহেবেরটা কোথায় ও পেয়েছো page 3 paragraph 4.
4, my lord.
Yes.
Top, my lord, subsequent to the dismissal of SLP on receipt of the decision of the railway board. My lord, kindly mark it.
Subsequent?
That is paragraph 3, my lord,
Yes.
second paragraph. Subsequent to dismissal of SLP and on receipt of the decision of the railway board, the railway administration has taken the matter of Ashok Sengupta towards the implementation of the order dated 2012-2023. Paragraph 4. I say that in pursuance and in compliance of the order dated 2012-2023 of the Honorable High Court Calcutta, the case of Sri Ashok Sengupta has been considered by granting second and third financial upgradation under MSCP's with effect from 1/9/2008 and 1/9/2014. But that I have paused for 1/9/2014. It should be 1/9/2013 because my date of my 30 years is completed as on 1/9/2030, and they have been thereafter respectively taken into consideration his regular service counting from the date of his regularization for the post of PWI grade 3 as on 1/9/84. That is also wrong, my lord. My date of appointment is 1/9/1983. And from the introduction of the MSCP with effect from 1/9 to that I have been disputing, my lord. My lord, I'll show the documents, my lord.
No, no, 1/9/2008, why you are disputing? From 1/9/2008,
not disputing. I am not disputing.
so you are disputing
Third MSCP benefit, only third MSCP.
third MSCP benefit they have given from 1st September 2014. It should be from 1st September 2013, according to you.
Because my date of appointment is 1/9/1983. And my lord directed entire counting office, that is counting for regular service, my lord.
Very good.
My lord, kindly see the circular, my lord. The MSCP circular, mother circular that is annexed in the writ petition, my lord.
Now, what is there? Come to page 11. They have given annexure R2.
Yes, my lord. Makali, before page 8 of their affidavit, my lord. Annexure R1, my lord, page 8. That is the service, the revised PPO they have issued.
Yes.
My lord, right hand side, my lord, the column, date of appointment. My lord, kindly see, date of appointment, right hand side. Page 8 of their affidavit, my lord. Date of appointment 1/9/1983. Net qualifying service 32 years. My lord, got it? And if that 1983, my lord, 30 years is completed in 2013. In 30 years. MSCP circular is third benefit. I have to grade, my lord, after completing the 30 years of service. 10, 20, 30. 30 years completed in 2013, my lord. 83, 2003. Thereafter, my lord, 83, 93, 2000, thereafter, my lord, 10 years.
It should be 10, 20, and 30.
Okay, 30.
So you were given the first MSCP benefit.
First MSCP I got
That is
promotion.
after
I got
10
one
years.
promotion.
Huh?
I got one promotion. That's why I got not first.
So why we to grant first MSCP on next?
Because I have got promotion.
It was given from 1st September 2008 to 89.
That is after completing 20 years of service and MSCP.
So that is completed in 83, 20 years completed is 2003.
Because the MSCP benefits introduced the scheme with effect from 1/9/2008. That's why they have been given. MSCP scheme said that will be effective from 1/9/2008.
This is in date of introduction.
There's a date of introduction.
Yes. Now, why they have not given? What is their
Their stand is, my lord, they have stated in the affidavit, my lord. That is at page paragraph 7, my lord. Paragraph 6 and 7. I say that from the text on tenor of the aforesaid second and third MSCP benefit has been granted to the petitioner. Furthermore, the area dues on a I further say that counting of seniority, it has been dictated by a catenary of circulars and notification issued by the appropriate authorities that period spent on training should not be counted towards fixation of seniority. Furthermore, the term regular service for the purpose of MSCP will commence from the date of actual joining of a post in direct entry gate on a regular basis. That I am disputing, that is wrong. This affidavit affirmation is wrong, my lord. Kindly see the main circular of the MSCP, my lord. That is annexed in the writ petition.
So they took the ground that by virtue of circular, the period of training should not be counted for fixation of seniority. And second ground is
Actual joining of the post in the direct.
Regular service will commence from the date of actual joining the post in direct entry grade on regular basis.
That was not the issue in the writ petition as
Now,
well as.
this according to
My
your
lord, there is no-
actual date of joining is 1983.
83. They have stated, my lord, in the service
Date
certificate.
of actual joining in direct entry grade.
Direct entry gate. That is my date of direct entry gate means they have said initially I was appointed 1983. There was I sent for training because that this post has created some training is necessary. I sent for training. They have curtailed by training because there that is that time as the emergency is declared. Shortage of staff is there. I have been not completed the 1 year training. I will completed 6 months training. Thereafter I has joined in the post. But the date of appointment will be that they will be counted the date of appointment that is in their PPO, my lord. My appointment date is 1983. They have curtailed the training period for the purpose of third MSCP. That is not the circular. That is the MSCP
Where
circular.
they have curtailed. Curtailed?
Curtailed in the manner when they have implemented this my lord's order. They have curtailed the training period. That is not the order of the my lord. My lord never said that.
You were in training for how long?
6 months.
After 1983, 6 months training. So at that time, MSCP was not there.
No, at that time MSCP is not there. SCP is there.
Now they are counting your service from 6 months after 1983. So it comes to 6 months in September, October, November, December, January, February, March. So it will be, they are counting it from 1st March 94.
84.
84.
84.
So from 84, 30 years takes you to 94, 2004, 2014. তাই জন্য 14 থেকে দিয়েছে, তাই তো? They have given you from third MSCP, they have given you 14.
1984.
1984. That is excluding the period of training.
That is not the circular says, my lord. That is not the MSCP circular says.
Show us MSCP.
Yes, my lord. Only the MSCP circular.
So that, Mr. Chatterjee, how can you argue in contempt?
Because that is not, my lord. This is intentionally they are my
Show
lord,
us the.
they are circumvent the my lord order, they are the personal bench, my lord, because I have filed a case, because I have win the case. That is my punishment. How? My lord, kindly see the MSCP circular. Page 115 of the writ petition. Bottom, my lord. I am starting my reading from second. In board office, several references from Zonal Railway has been received seeking guideline regarding admissibility of financial upgradation under MSCP scheme. My lord, got it?
This is MSCP.
Yes, MSCP circular.
This came into effect from 1st September 28.
Yes. My lord, I am reading, my lord. In this connection, my lord, there is from bottom 1 to 3rd paragraph. In this connection, attention is invited in para 1 of the annexure of board's letter dated 10/6/2009 RB, where it is mentioned that MSCP scheme envisages 3 financial upgradation counting from the direct entry gate on completion of 10, 20, and 30 years of regular service, respectively. Financial upgradation under the scheme is admissible wherever an employee has spent 10 years continuously in the same grade. Okay, same grade pay. It is thus evident that first financial upgradation would be admissible on completion of 10 years regular service from the date of actual joining in the post in the entry gate. I am not disputing, my lord, 10 years. Second financial upgradation on completion of 20 years service from the date of initial appointment, or 10 years from the date of first financial upgradation stroke promotion, whichever is earlier. And third financial upgradation would be admissible on completion of 30 years of service from the date of initial appointment.
Just.
Or
just. Firstটা হচ্ছে from the date of actual join. Secondটা হচ্ছে on completion 20 from the date of initial appointment. Completion Initial. So it should be counted from the date of initial appointment.
Yes, date of initial appointment, not there is no question of
Then
any
what is
training.
meant by actual joining to the post in the
That
entry?
means after training, Malad, I have in the directive, that is they have cut actual joining.
So your
Actual joining.
completion of 10 years will be counted from the date of actual joining.
That is 10 years, the first MSc, the third.
Yes, first MSc,
10 years from actual joining from the post.
So actual joining will be after training.
After training.
Huh?
But second and third MSc, that is not said.
From the date of initial appointment.
Initial
that is
appointment
subject to actual payment.
No, date of initial appointment means, my lord, they have counted my service from the date of initial appointment in the PPO, my lord. PPO, my date of appointment is, my lord, kindly see the date of appointment is 1983.
Yes, they are.
That is the appointment date.
They are giving you all benefits counting your entry into service from 83. But that entry is not actual appointment. Actual appointment will be after completion of training.
That is not the issue here, my lord. My lord, direction was not that. My lord, they never said
No,
that.
no, you are showing, you are telling us that this act, it should be from the date of appointment. My date of appointment is 1983. PPO shows that. So now you cannot deduct the training period from my, then what, is there any definition of actual service here?
MSCP 10 years, in MSCP circular, my lord. Kindly see the MSCP circular.
10 years of regular service.
Regular service means, my lord, date of appointment. My lord, kindly see again, my lord, that circular, my lord, in second paragraph. Further, the illustration under para 28 also demonstrate that first financial obligation would be admissible on completion of 10 years of regular service from the date of
How long will you take?
10 to 15 minutes. The only issue is what is the actual date of joining. That is the only issue. Whether training period will be curtailed or it will be considered. That is the only thing. In fact, that was not the issue before, my lords. So the contempt does not lie to that extent.
Newly they have added this.
That is not the issue. They have to file a fresh writ petition then.
Tomorrow? You will be there tomorrow?
Yes.
তো এটা কালকে কোনো উপরে ফিক্স নেই তো এইটাকেই কন্টেম্পটাকে উপরে করে দেবে হ্যাঁ কালকেই আছে
Let me 2 p.m. or
কালকে 2 p.m. 2 p.m. tomorrow won't be possible. ওই কল্যাণ ওই
or day after tomorrow, my lord, I have.
The day after tomorrow, let us fix it.
day after tomorrow.
No, no, my lord, I have difficulty day after tomorrow. My lord, may I pray for an dictated order? I am representing the authority.
তাহলে ফ্রাইডে রাখবো ও ফ্রাইডে বেঞ্চ নেই দুটোর সময় প্রাইমারি ম্যাটার ফিক্সড হ্যাঁ সকাল
Well,
will be fairly at the
may I pray for an order?
আচ্ছা হার্ড মিস্টার চ্যাটার্জি learned admitted appearing
দিয়েছি কতদিন
We've recorded the submission.
রেকর্ড করে করতে অ্যাকশন ছিল ওরা ছিল কি ওটা ছিল there was direction to produce the records তাই তো not recorded না না ঠিক আছে
Yes.
Your Lordship, the petitioner has preferred an appeal against the order of dismissal passed by the Honorable Single Bench of this Honorable Court, thereby dismissing their petition, whereby the petitioner, the appellant before Your Lordship, was dismissed from service because of his conduct as shown in the charge sheet. The preliminary argument as advanced by the appellant before Your Lordship is that initially they have challenged the transfer orders. Initially, he was in SME branch. Thereafter, he has been preliminarily transferred to ARM branch, and from ARM branch to Siliguri. But all those transfer orders were not in accordance with norms of banking, and he was challenging the same. So the Lordship, after perusal of the entire records and the submission as advised by my learned senior friend before Your Lordship, as it appears that the entire facts has not been pleaded before Your Lordship, because the fact remains that thus I have filed on the last occasion, Lordship, I have also filed what was the reason for dismissing, or rather from his service. The reasons I have shown on the last occasion, Lordship, I have filed the list of dates, which reveals the conduct of the appellant before Your Lordship, how he was discharging his duties with the bank. Your Lordship, the entire list of dates, if Your Lordship, it starts from page 1. There may be typographical error, your lordship, on the last occasion I have submitted. I pardon for that because it was prepared in very haste. So, lordship, the first cause of action initially arises on 14th of September when the petitioner sick ill in the office itself. And thereafter, the officials will send him to the CMRI. The CMRI doctors were examined him and send him to the office without any the doctor's instruction to take rest. He joined the office on same day, 14th September. On 15th of September, he absent from the office without any leave application. 15th of September, he absent from the office. On 16th of September, the apparent wrote a letter to the AGM, SME Finance Branch, that he had consulted with the doctor on 15th September and advised by the doctor to take rest. But such formal intimation was uncorroborated because as per the banking service rules and regulations, as on the last occasion relied upon by my learned senior friend before your lordship, if any employee of the bank, if wants to seek any leave, he have to make an application and that will be subject to approval of the authority. Without that cannot be, and in unavoidable circumstances, if no such leave, prior leave can be taken, he can corroborate the same subsequently with medical certificates. This was. So he has made on 15th September without any application, he was leave. On 16th September, he simply wrote a letter, I am not coming because I am not feeling well. The reasons for unwillingness was, lordship.
The voice is quite loud.
Thank you. Lordship. The reason for his illness was vertigo. The illness was not of such a nature.
It was posted at
SME branch initially.
He was in SME branch.
SME branch. Indian Bank SME branch, 7 Red Cross Place.
Now, this order of transfer which you have issued.
Yes. The order of transfer on the last occasion which we are referring to, appearing at page 155.
Page 155.
No, 155 is CP. He has shown that the transfer order was for the first time sent to him on 30th March 2016.
Yes, though it was dated 11th March.
Yes, but factually incorrect. He has not placed the entire record before your lordship.
You apprise us that now from he was transferred from SME branch by this order to where?
To ARM branch on the first floor of the same building.
That. He was transferred SME branch on 11th of March.
11th of March.
ARM branch.
To ARM branch situated on the first floor of the same building. SME was on ground floor, ARM on the first floor.
This is not the subject matter of the charge sheet. Transfer episode is a separate episode.
The charge sheet contains lordship.
No, we will come to that.
Lordship.
Let us understand. There are
Lordship.
plenty of facts now.
Lordship.
So, which order of transfer did he challenge?
He challenged both the transfer orders.
Now, where is the next transfer order?
The next transfer order, your lordship, is appearing at page 160.
That is dated
Lordship.
1st July 2016.
That is to Siliguri.
1st of July 2016.
This was to
transfer to Siliguri Zonal Office. Page 160.
So this was on 1st
July 2016.
Now, this was issued by the Assistant General Manager of which branch?
SME
branch.
SME branch.
But from SME, he was already transferred.
No, that is the question which he is not argued before your lordship. He simply tried to take as much as technical grounds.
Tell us
The, the factual correctness is that the first transfer order, which was passed on 11th of March 2016 from Assembly branch to ARM branch, that was sent to him by post. The postal article, when reached to his house, he reluctant to receive the same. Intimation was served by the postal authorities.
This intimation of
Transfer order, first transfer order from SME to ARM.
where is that by post communication?
Lordship. The by post
contention is he was never communicated.
No. That is, though the materials on record available.
That's very good. Tell us which page.
Lordship, the page is 319.
That is in the next paper.
Next paper book, which my learned senior friend has not placed. I can understand because he can only argue his case. Page 390. So this was the transfer order, Lordship.
Yes.
And this transfer order, if your Lordship kindly turn to the page 321 and 322, 23.
No, page 155. It was sent by the SSC online on 30th March.
Yes, since he refused to buy this, that is why. The first attempt was made by post. But the contention of the petitioner, he never received any such notice. Lordship, kindly peruse 319 is the transfer order.
Yes.
Page 321 and 23 shows it was posted by post to the appellant by the bank. And your Lordship, 323 shows intimation served on 18th March 2016. 323. 18th March 2000 intimation served by the postal authorities since he reluctant to he refused to rather. Yeah, I am not in home. He has informed postal authorities, served an intimation to his residential address and hold the article up to 19th March and returned it back to the sender, that is to the respondent bank, with not claim. So Lordship knows not claim tantamount to good service. It is not his case कि he left the house, postal article tender is in residential house, returned with address he left.
Yes, all right.
But the article shows it was duly tendered, intimation served to the persons were there in the house and returned back with not claim.
What does absent
Thereafter,
at 324? What does absent mean?
Lordship?
What does absent mean? It's 324.
Absent means, your Lordship, literally the postal authorities, whenever gone to the tender to the addresses, they reach to the house of the addresses. When the postal authorities found
he's not there.
Is not there.
So
they will, as per the postal Lordship.
What is the date of that signing of that absent intimation?
18th of March 2016.
Come to 324.
Page 223.
324. Come to 324.
Lordship.
What's
Yes,
the date?
it is a type copy. But type copy kindly peruse. Because I am not the author of this. It is the author is the postal authority. Type copy is the author of the appellate. Lordship, February cannot be held up to March. February cannot hold up to March.
Yes, this was the first episode.
This was the first episode.
Now
he refused to. Thereafter, the bank has sent by email.
That is page
155, Your Lordship,
30th March.
30th March. This note, he is not disputing that the email address is not correct. He has duly communicated. But despite of receipt of this communication for the second time, he reluctant to join the ARM office.
So when did he join?
So Lordship,
Now the second transfer order was issued on second transfer is at
1st
page-
July,
160.
Page 160.
Lordship,
1st July.
1st July.
Yeah. Yes, please first give that explanation. This transfer order which is at page 160.
Lordship,
Second transfer order.
Lordship,
That means his argument that this is without jurisdiction
Lordship.
because this was issued by the SME branch from where he was already transferred.
Transferred.
To 11. Yes.
Let's. So answer to that, my respectful submission before your Lordship will be obviously subject to your Lordship kind acceptance of the same. Though he has been transferred from SME branch to ARM branch, he was supposed to report there, but he did not, which means he has not accepted the order of transfer by his conduct. In the bank's record, he has been transferred. Now, he is supposed to discharge his due diligence by approaching the transfer branch, reporting that I am joining in terms of the order of transfer. But he did not. So the order of transfer he has not accepted.
So from 11th of March 2016 till the 11th of July 2016, he was absent
He was absent on one ground and another.
from just a moment.
Let's say the list of dates will peruse.
But your period of absence in your chart sheet, you have shown it from 18 November 2000.
Yes, but prior to that, November, but before that, he was continuously absent on one ground and another. His previous conduct was.
So he was absent since 11th of March 2016.
Lordship, in my list of dates.
Achha, sure, sure.
Lordship, kindly see the list of dates. Because his absence starts from September 15. September 15, he was continuously absent on one ground and another.
2015 to July 2015, you said he did not join.
Lordship.
Now, he preferred the writ petition.
Yes.
Challenging 1st July transfer.
Yes.
Writ court said join within 90.
Within 10 days.
Where is that order of the
Lordship, the order of the Honorable Court is at page
70?
Yes.
So writ court said join within 10 days.
Within 10 days. Within 10 days.
To Siliguri.
To Siliguri. Your place of transfer.
But he did not.
He did not. The content.
Thereafter, he filed an application for amendment.
Amendment.
Amendment was allowed.
Amendment was allowed.
Where he took the ground of malafide.
Malafide. Lordship.
Now, what had been the fate of that writ petition?
That writ petition, because subsequently charge sheet had been issued, that writ petition got dismissed because he has been already.
After charge sheet, I was removed. Statutory appeal was preferred. Statutory appeal was held against me. After that, writ petition was disposed of. Since first writ petition.
Then you came and challenged this. So, what is the date of dismissal? That order is here. That order is not here.
No.
Order of
dismissal of first writ petition.
Oh. Last question, I have handed over the order.
Handed over what?
Order of the
dismissal.
Disposal of the writ petition. Yes, this one. It's
sorry then I. So it was dismissed on 29th June of 18. of May 2008. Right. After statutory appeal order, this petition was dismissed.
Lordship. So, Lordship, he has not only disobeyed the order of transfer passed by his appropriate authorities, who is the institutions, but he is also the guilty of non-compliance of the direction of the Honorable.
That is a charge.
That is
a
the charge.
you have taken in
Yes.
your charge.
The charge taken in the charge sheet not because of the repetition, but we have drawn an inference. He is also the guilty of non-compliance of the order of the Honorable Court.
Very good. Now tell us what happened after July 2015.
After July 2016, when he has got transferred.
Now 23rd August, he was asked to join Siliguri.
He was asked to join Siliguri.
Then what happened?
Once again, as similar to the first transfer order, he is supposed to report it to ARM branch. He once again.
One interruption. So you are from 11th of March 2016. Your list of dates starts from 2015.
Because I want to show his previous conduct also.
Previous conduct was a subject matter in your.
No, but only to draw an inference before the court, the conduct. The conduct of the appellant.
But previous conduct, can you take into account?
No, that is not the subject matter of also charge sheet. That is also not the subject matter of
All
charge.
right, we have seen those. So let us start from 23rd of August 2016.
From July 2016, Your Lordship, I have seen a Sokas notice was issued to him. 1st July, he got transferred.
1st July.
He got transferred. He is supposed to report to the ARM Zonal Office Siliguri. He once again not reported there. That means second transfer order, he once again not acted upon. On the part of the
Second transfer order, he challenged.
Second transfer order, the challenge is the second transfer order was communicated by the Assistant General Manager, SME branch. Whereas once he transferred to ARM branch, how the AGM SME branch can communicate such order? But since he has not acted upon the funds transfer order, he remains in SME branch because he is supposed to report it, which he did not.
So the ground of challenging the writ petition was without jurisdiction.
Without jurisdiction, only.
In which he was asked to join within 10 days.
Within 10 days.
Very good. Now, we are concerned with the charge sheet absence.
Lordship.
Now, show us. So, tell us what happened after July 2016.
After July 2016, he is supposed to join Journal Office Siliguri.
So, your argument first is starting from 14th of September 2015.
He was a habitual absentee, though it is not a subject matter of charge sheet.
List of dates.
Yes, list of dates.
That will show that from 14th of September 2015.
He was the
1st of July 2016.
Lordship.
He was all along absent. No, he came and joined one day again.
2 days, 15 days leave. 3 days, 10 days leave. 2 days, once again 15 days leave. Absentee without any proper application. Because I am working with an organization, I am guided by the rules and regulations of the organization. But I was working in the organization as per my whims and fancies. Whenever I like, I will go. Whenever I will dislike, I will not go. The entire reasons for absent was only the illness of vertigo.
So his wife was also sick.
That is the subsequent development of the ground of illness. When the SOCOS notice has been issued, when he did not turn to join the zonal office Siliguri.
SOCOS notice.
What's the SOCOS notice? So let's say I am showing the SOCOS notice. Volume 2. Yes. Let's say the SOCOS notice is appearing at page 341. Second paper. 341. What my learned friend is placed before your lordship through communication by mail, but it is also sent through post. Once again returned, not claimed.
Which one? SOCOS.
SOCOS notice appearing at page 341. He always declined to receive the official communication by post. Always. Or let's see, kindly see the postal authorities remark once again not claimed.
SOCOS at page 340.
341. The respondent bank giving him an opportunity to explain the reason with corroboration about the delay as mentioned in the table. Send it by post. He declined to receive. Intimation served. Once again, the fate is unclaimed. Returned to the sender.
That is page.
That's it. That is page 343.
343.
343. Unclaimed.
Yes. Then came the charge sheet.
Then the charge sheet came into picture. Since he was reluctant to receive any official communication regarding first transfer order, second transfer order, he was reluctant to. SOCOS notice, he reluctant. But the appellant has argued before your lordship, he was not
answered later.
Yes.
First complete your fact.
Yes, yes. So these are the reasons.
Then
Under such compelling circumstances, the authorities has decided reluctant attitude and non-responsible attitude of the appellant decided to issue charge sheet on 15th September 2016. That 15th September 2016 charge sheet contains the entire proceedings with corroboration. Statement of article of charges, statement of imputation of charges framed against the appellant, the provisional list of documents relied upon by the bank, and the provisional list of witness by whom articles or documents were supposed to be produced before the inquiry. These documents.
Where is the inquiry report?
Your lordship, first of all, your lordship, let me place the charge sheet which was sent to him. Your lordship, the fate is same. 345 is the memorandum of charge along with all annexures up to 352. 353 which was posted to him by post. 353.
Yes.
354 is the result is same, unclaimed. Type copy, it was written unclaimed. Yes, 355. Intimation served, unclaimed. SOCOS notice, not received. Charge sheet, reluctant to receive. Paid, same. So kindly see the blameworthy conduct of the appellate before your lordship. This is not a case that the ex parte order has been passed without granting an opportunity.
All right, you summarize your argument.
Yes. So this is your lordship. Thereafter,
Yes.
your lordship 359.
Now, what-
359. Kali also there is 359, the intimation. In the month of September. 359. The date is September 2000. Intimation served. 359 regarding charge sheet. 359.
350. You showed us 355 first.
Yes.
355 intimation given 29 March 2016. How can it? This is show
No,
cause.
this may be a show cause. This may be a show cause. And lordship, the last 359 is the charge sheet. September. 359 is the charge sheet. Return,
Same result.
same result.
Then what happened?
Thereafter, your lordship,
Published a paper address.
we published since the petitioner appellant reluctant to response to the official communication. The bank has decided whether he was also reluctant to answer the email also. So considering his conduct,
Were sent by email also.
the transfer order which my learned senior friend has placed before your lordship, the first transfer order 159,
That is all.
55, he did not report it. So considering his past conduct, the authority decided to make a publication in a white circular newspaper.
That is page 367.
367, 368 is the type copy.
What is the date of this publication?
So the date of publication is, the date is not here.
All right, next.
This is not, but this publication is not disputed. The bank has not.
Next, proceed.
Your lordship, this publication thereafter, despite of this publication, he did not turn up once again. Sitting idle in home. Being a responsible officer of an organization, sitting idle. On the ground of only one ground, the entire medical certificate annexed to the writ petition is referred to the illness of vertigo. Position ought to have been different.
All right. Then fourth page 369, the inquiry officer.
The inquiry officer. It was once again sent by post.
Where is that service?
Let's see, the service I have perused, I do not find, but kindly peruse page 377. July 17.
January 2017.
No, that's it. One by one. Your lordship, 369, send it by post. In the middle portion, postal article is affixed. 10th of September 2017. The date is appearing.
10th or 18th?
No, this is lordship 18th. Right. Yes.
2007.
It has not been denied. It was not posted. But the case is trying to make out before he changed his address. If he changes address, the law is well settled. If you are changing your address, you have to inform to your organization and to the postal authorities. Rather, if any article sent to me, kindly, but the postal authority is sending the remark unclaimed, which means he was very much there. He was residing there. Rather.
Very good. Then,
despite of this, he did not turn up. So he allowed the entire proceeding. It starts from SOCO's notice till the date of order. Expired. Rather, his specific averment in the appeal, your lordship, kindly peruse. I have found one statement. Page 10. Page 10 of the volume 1. What is his statement? He's saying charge sheet was not served upon me. I was not aware. I was completely in dark. malafide conduct on the part of the bank. What is contention in his writ petition on affidavit? Petitioner stated allegation in the charge sheet were vague, and thus petitioner could not to file any written defense. Meaning he decided the allegations are vague, so I will not make any representation. I will not appear before the authorities. He allowed the same to proceed ex parte. And if such being so, I am putting this question.
Non-communication was not stated in the writ petition.
That's it.
Writ petition, his statement was that I did not file written statement.
Yes.
That
Since
is
the
what-
allegations are vague. So you are saying, yes, charge sheet may so many cause, but since the allegations were vague, I decided not to file any written version. Now, after this specific averment, after showing the conduct which I shown to your lordship, can he blame the entire proceeding, which the bank on each and every step trying to communicate him?
So in writ petition, he did not say this thing, non-communication, etc.
He simply denies whenever communication was sent to me, I was not in receipt. But the affidavit in opposition with well corroboration was not controverted by rebuttable evidence. He has shifted elsewhere. This is the latest address where bank was aware, not sent to me. This was not his case.
Very good. Now the appellate authority passed the order.
Now the appellate authority has passed the order. His another contention was the appellate authority has not passed independent order.
Now come to the appellate authority order at page 192.
Page 192, your lordship. Lordship.
Now kindly come to page 193, third paragraph.
Yes.
Place.
First, second, third. Meantime, due to some administrative reason, Mr.
No, that
Sachin-
is your next para.
That's right. As the charge officer, Sri Das, remained on unauthorized absence, the said DA order, along with inquiry officer's report, was sent to his recorded residential address by post on 4th of September 2017 for his comments. It
4th
was
of-
returned
wait.
undelivered. It was returned undelivered. Thereafter, notices were published in the local newspaper on the date of publication. The lordship is inquired is here, 27th of October 2017. Advising Sri Das to collect the inquiry officer's report from zonal office, Kolkata, Metro, within 5 days from the publication of the notice. However, Sri Das neither came to the office to collect the report nor submitted any representation in this regard to the disciplinary authority. So the principle of natural justice was also duly and due diligence taken care of by the respondent authorities. And lordship has also seen the same. I am not repeating his conduct. And thereafter, on the basis of that, the lordship, the charges leveled against him, he has not denied that he was absent. The period of absence as alleged in the charge sheet is not in denial.
No, his argument was that I was not allowed to join.
Yes, his argument was he was not allowed to join, which is also contrary to the materials on record.
Show us.
Lordship, the communication one after another given by the bank, asking him to explain, he reluctant to. What kindly peruse page 211, because the multiple facts are there, your lordship, also. I must be candid before your lordship. This is the highest court of the Calcutta High Court. I do not sigh to say this. This is for the first time In division bench, I accompanied by the seniors. For the first time, I am addressing myself.
There is no learner's license in advocacy.
Lordship, no learner license.
Yes.
But I'm trying my level best. I have worked hard to
Yes.
place the facts. So 5th of October, Lordship, kindly see the communication issued by the bank.
Page
211. Lordship, the respondent authorities multiple communication given to him with the request to corroborate your absence. But he was so egoistic. He was fighting with the authorities by making false allegation against his superiors.
211.
211.
Yes, what you are showing us?
Your Lordship, the bank has asked him to show the medical.
Where you are reading?
Lordship, page 211. The caption is your absence from duty since September 2015 on medical grounds.
Page number may be different.
Maybe different. Oh,
277.
277. I tender apology, Lordship, because in my page it has been vanished. The start part of 7. That is why I am reading 211. 277.
277.
Lordship.
Yes.
The authorities made him a request to corroborate your absence.
This was of 2015.
And so on. And so on.
Show us proximity with the chart sheet. Proximity with the chart sheet. You show us.
Let's say I'm coming. Let's say 211, 15th of October. The letter, he did not, he simply placed one certificate saying vertigo.
Page.
Vertigo, doctor certificate, he was referring to 280, the type copy. The doctor certificate is 281.
and
281 is the doctor certificate. Kindly see the nature of disease. We see trying to impress upon the court he was ill.
Yes.
Vertigo.
Accompanied with vertigo. There were 2 diseases.
Yes. But the nature of this disease, as I have made a study, was not as such serious in nature. The person won't be able to join his office.
Yes.
There are lots of, thereafter the lots of, I am placing the other communication of the authorities.
So, no, very good. This is not the subject matter of the chart sheet. What you are showing us.
No, lots. I am coming.
Show us those representations which were issued pertaining to the period as specified in page 84.
Page 84.
Page 84 is your statement of imputation. Statement of imputation.
Start from November 2015.
Show us from there.
Yes. 277 was dated, well, let's say 5th of October. Now I have to start from November.
Last page of that first volume is page 16 December 2015. Your absence taken note of is from 18th November 2015.
Yes. So the authorities issued him a letter on 16th of December, which he is not disputing, rather was in receipt of the same. And the authorities what stated? It has been reported by the Assistant General Manager of your branch that you have been remaining absent from the branch frequently. which has adversely affected the working of the branch. In this regard, you were asked to furnish your explanation while later dated 3rd December 2015. But you did not submit any reply when the Assistant General Manager advised you to submit the reply on your reporting at the branch on 16th of December 2015 at 10 a.m. You started to argue with him and left the branch without joining. Your such act of indiscipline is not acceptable and you are advised to submit your explanation for the above act through the Assistant General Manager of your branch to the undersigned within 3 days of the receipt of this letter. So before that also, possibly in my second volume, the bank has made multiple requests to the appellant before your lordship to submit his explanation with corroboration. But to the reasons best known to him, he was continuously as a habitual.
That you have argued.
Yes.
What do you want to show us next?
Yes. So, considering entire things, your lordship, to kindly peruse the charge sheet now. Because he reluctant to receive. He said, bank never made any attempt. I have shown, your lordship, it has been made an attempt, returned undelivered because of his conduct. Your lordship, the charge sheet leveled against him is appearing at page 79. The memorandum of charge sheet, your lordship. And the articles were charged is at page 82. The first article which charged against the appellant was he proceeded on leave on several occasions without submission of proper leave application and without obtaining permission of the competent authority. So this is not in denial. He was the habitual absentee from the office without any proper leave application. And if your lordship kindly peruse the your lordship, Allahabad Bank conduct rules, your lordship. Allahabad Bank Employees Conduct Regulation 1976. Your lordship, kindly peruse the contention of my learned senior friend before your lordship was that the article 3133 and article 24 was there, but 13 was absent. The mere non-mentioning of article is not going to.
Article 13.
Article 13. The manner of taking leave from the organization. You are also relying upon this, being an employee of the bank. You are guided by the Allahabad Bank Officers Conduct Regulations. Also, kindly peruse the absent from duty, Article 13. 1. No officer, employee shall absent himself from his duty.
Where do you are reading?
Or be late.
Huh? Where you are reading?
What's the Article 13?
13.
Allahabad Bank, yes, 13. 1, 3.
Allahabad Bank officer employees discipline and appeal regulation.
No. Conduct regulation.
You have not given us.
In my compilation.
The charge sheet was issued under what? Under
the charge sheet was issued under the lordship in terms of.
It was in terms of Allahabad Bank Officer Conduct Regulation.
3.1.
Conduct Regulation.
Yes, Conduct Regulation.
Conduct Regulation, where do you have annexed?
Your lordship,
yes. Which clause you are showing?
Your lordship.
13.
13 appearing at page 12 at bottom.
Yes.
Your lordship, absent from duty. How? No officer employee shall absent himself from his duty or be late in attending office or leave the station without having first obtained the permission of the competent authority, provided that in case of unavoidable circumstances where availing of prior permission is not possible or is difficult, such permission may be obtained later subject to satisfaction of the competent authority that such permission could not have been obtained earlier. 13.2. No officer employee shall ordinarily absent himself in case of sickness or accident without submitting a proper medical certificate, provided that in case of a temporary indisposition or sickness of casual nature, the production of medical certificate may, at the absolute discretion of the competent authority, be dispensed. So, Your Lordship, the regulation 13.
What was his argument?
So,
what was his argument?
His argument is because as per the Article 13, he has to make an application and subject to satisfaction of the authority. And if the authority declines, you have to be there in your office because you are holding a responsible post, discharging a public duty, being a nationalized man. But he never made any endeavor, save and except in the morning, sending an email, I am not coming. I am not feeling well.
Yes.
And this was so on. It was not a single incident that he has occurred for a couple of days. It was so on for the charge sheet period, entire charge sheet period, his conduct was as such. And the medical certificate he wants to impress upon the court, it's talk about vertigo with other
Yes.
disease.
What is your next argument?
So, considering the entire, thereafter, Your Lordship, kindly come to the Article 1, Article 3.1, the charge sheet, in the charge sheet.
Yes.
And 3.3, 3.1, 3.3, no? 3.1. Contribution to the Lordship, Article 3.1 is, Lordship, I tender apology, Lordship, kindly.
3.1
is appearing at page number, Your Lordship, 7. Page 7, running page 7 of his compilation. Article 3.1.
Which compilation?
The compilation filed by my learned senior. The Allahabad Employees Conduct Regulation.
Yes, that is
which he has annexed. So, Lordship, that is Article 3.1. Appearing at page 7 in the middle.
That is the regulation under which he was charged.
Yes, yes. The regulation under which he was charged. 3.1, 3.3, read with 24. His contention, we have argued before the Honorable Court, he was the habitual absentee without any proper application. His argument, not only before the single bench, but also before Your Lordship, is that Article 13 is not mentioned. But the Article 13 is talks about absence. And the entire articles will talk about his absence. So mere non-quoting of article will not render the charge sheet bad or invalid.
Yes.
Well, also the article, thereafter the next article in the charge sheet was, despite of the transfer order, he not only reluctant to join ARM branch in terms of first transfer order, in terms of the direction of the higher authorities, superior authorities, but he also failed to join the second place of transfer. Not only in terms of the direction of the, or rather communication of the authorities, but also in terms of the order of the Honorable Court. There we have taken the reference of the Honorable. So, Your Lordship, the Article 3 1 and 3 covers everything is conduct. What? Every officer employees shall at all times take all possible steps to ensure and protect the interest of the bank. But he was absent from the office. He was not taking care of the interest of the bank.
Please don't repeat. Yes, we understood.
And your lordship, Article 24, which my learned senior friend has argued before your lordship, is that is vague. So my respectful submission, your lordship, is not vague. Rather, it's page 19. The conduct rules regulation, Article 24, which was mentioned in the charge sheet. Read with 24. The 24 acts of misconduct. So, lordship, a breach of any of the provisions of this regulation shall be deemed to be constitute misconduct.
What was his argument you are saying?
No, he was saying the Article 24 is vague because it's not disclosed what misconduct. My counter submission before your lordship is that the language itself is very much clear. Breach of any of the provisions of this regulation shall be deemed to be constitute misconduct, punishable under the Allahabad Bank Regulation Act 1976. So he was in breach of one.
He was saying that we have the allegation of misconduct is very vague.
No, it was his argument.
His argument was allegation of misconduct. First, there has to be a statutory misconduct. Unless the misconduct is referred to in the regulation, you cannot borrow some other sentence and put it.
Cannot.
His argument was that the misconduct which you were alleging does not in fact come within the purview of the regulations also.
That's Article 3, Article 3.3, Article 13, where he was absent from his service, or any violation of these articles tantamount to misconduct in terms of 24.
And he also argued that your allegation was not of willful absence.
But the statute is not so willful absence.
That should be reflected in the charge sheet. What he has argued was that Krishnakanta, he relied that if it is absence is willful, mere absence will not allow you to hold me guilty. You have to establish that my absence was willful.
But your lordship, the absence will be guided by the conduct regulations. Conduct regulation does not say so. If the conduct regulation does not say so, he cannot inference a word from the judgment and apply to these facts of the case.
He is not doing so. He is saying that you are not doing so.
Lordship, we are guided by
this charge, you said of unauthorized absence.
Yes.
It was not a deliberate willful act on his part. That was his submission.
Yes.
That I was sick, I intimated, I was never communicated any comment. That was his argument.
Yes. So my submission before your lordship, since you have violated Article 13, absent from office without proper application and approval of the authorities is a misconduct, which you have not denied.
Which you have not denied means?
Lordship, he has not denied that I was absent. I was squarely covered with Article 3.1.3.3, Article 13 and 24. Rather, he is relying upon these articles. And if you are relying upon these articles, the articles saying so your misconduct, Article 24, violation of 13.3.1.3.3, you have not discharged your due diligence to the institutions. You have not taken care interest of the institutions.
Yes, yes. Anything else you want to show?
So, Lordship, in this way, your Lordship, the charge sheet has been issued. Thereafter, he has been terminated from his service. Now, the Honorable Single Bench, the argument as I advanced before your Lordship, has duly taken judicial note of the same, taking a reference from the authorities of the Honorable Apex Court. Lordship, with due respect, Lordship, I am guided by one judgment.
Show us those portions of the judgment.
Lordship, may I? Before your Lordship, I have to show there was no irregularity or irrationality on the part of the Honorable Single Bench in dismissing the writ petition of the appellant before your Lordship.
Yes.
So let's say page 432 onwards. The observation of the Honorable Court. Considering the entire reluctant attitude, non-responsible behavior, and violation of the service rules.
Where do you
Let's see, last paragraph 432. The petitioner was handling the foreign exchange service of the bank. Non-reporting to the work in such an important department certainly caused inconvenience to the bank. The petitioner, by letter dated such and such, addressed to the assistant general manager of the bank, intimated him that there was a huge workload and he was verbally requested to reduce his workload, being aware of the fact that he was holding a responsible post.
He was a manager.
He was a manager over there, handling foreign exchange.
He was holding quite important post.
Lots.
Quite an important post.
Lots. So the court has taken judicial note of the same. Single window operating cast application of she was manager of 345. Pion ছিল না.
He was a manager, Mr. Shamim.
He was an scale 1 officer. He was never charged with as.
He was a scale 1 officer.
Scale 1 officer, Your Lordship. Even 2, 3, 4 also. The categories of manager are 1, 2, 3, 4.
Yes.
Lordship, then the next page, 433.
Maximum. Yes.
Your Lordship, 433. Your Lordship, the observation of the Honorable Court after perusal of the entire materials on record on the part of the appellant as well as the respondent bank. The first paragraph, the bank initiated a disciplinary proceeding against the petitioner on account of certain irregularities committed by him. There was as many as 5 charges mentioned in the statement and the article charge frame against him. 3 out of 5 attempts relates to the absence from work without obtaining prior permission and without submission of proper leave application. A further charge of not joining transferable place of posting in violation of the order passed by the High Court has also been leveled against him. According to the bank, the same amounts to misconduct. Let's see Regulation 24. Thereafter, the petitioner has challenged the same, as according to him, the regulation dealing with the absence was not specifically mentioned in the article of charge issued to him. The charge sheet mentioned violation of Regulation 3.1 and 3.3 of the Conduct Regulation. However, Regulation 24 relates to misconduct has also been mentioned in the article of charge. The Regulation 24 of the said regulations mentioned that a breach of any of the provisions of regulation shall be deemed to be continued misconduct punishable under the regulations. The charge leveled against the petitioner clearly mentioned the fact of his remaining absent from office without any valid permission and without submitting any documents. The same is in violation of Article 13, which certainly amounts to a misconduct punishable under the Regulation 3(1) of the Conduct Regulation is general provision, which mentioned that every officer employee shall at all times take all possible steps to ensure and protect the interest of the bank and discharge his duties with utmost integrity, honesty, devotion, and diligence, and do nothing which is unbecoming of a bank official.
So the court proceeded on the basis Regulation 13 has been violated.
Yes.
But 13 does not feature in the charge sheet.
Only. But the ingredients of 13, if your lordship take a charge as a whole, was very much available. Possession ought to have been different with due respect subject to your lordship kind consideration. If the allegation of absence is completely altogether vanished from the charge sheet, then the submission of my learned senior friend ought to have been sound or hold much water.
Yes.
So thereafter, your lordship, kindly peruse the second 434 second paragraph. The aforesaid provision laid down the general principle that are required to be followed by the officer employee at the bank. The act of the petitioner in absenting himself from the work without any intimation is in direct conflict with the provisions of Regulation 3(1). Being absent from the work without prior intimation causes serious prejudice to the bank and poses problem in general administration and day-to-day function of the bank. The same is not in the interest of the bank, but is against the bank.
All right, Mr. Singh, you summarize now.
Law. So let's say the Honorable Court thereafter yes. Kindly see the conduct. Let's say 435, the Honorable Court has dealt with. 435 second paragraph. The notice of show cause, if you lordship, I'll take out the last 4 lines. No, from 1, 2, 3, 4. 4th line from the top, second paragraph. The bank has relied upon the Regulation 20 of the D&A regulations, which mentions that every order, notice, and other process made or issued under the regulation shall be served in person on the office employee concerned or communicated to him by post as his last known address. Admittedly, the notices and the processes of the disciplinary proceeding were communicated to the petitioner at his last known recorded address. The same returned answer. The bank thereafter made a public announcement in the newspaper. The petitioner did not respond to the same. The petitioner tried to make out a case that the bank ought to have communicated the notice and the process via email, as the petitioner regularly communicated with his prior superior officers via email. The contention of the petitioner cannot be accepted, as the mode of service of notice has been clearly mentioned in the D&A regulations of the bank. Servicing a copy via mail may be a supplementary communication in addition to the prescribed mode of communication, but the same cannot be treated as a primary and the only mode of communication. If the mode of communication as prescribed in the regulations has been followed by the employer, then the same has to be accepted as a valid communication, irrespective of the fact whether a supplementary additional communication via email has been adopted or not. Here, Your Lordship, we have sent an email by post. We have sent the communication by post. He reluctant to receive.
Very good. Now you summarize, this is your argument.
So my submission before Your Lordship is that
First was habitual absentee.
Habitual absence.
Reason for absence was medical issue which was given was not of a serious ailment. It was vertigo. Third was that he has, even if regulation 13 has not been referred to, issue has been dealt with by the learned
Yes,
single
all the ingredients of Article 13 was very
are
much in the
very
charge.
much. And fourth is that the factum of absence is not denied.
Yes.
He has not denied that I was present, but you marked me absent.
Yes.
His argument, your argument was that he has admitted his absence.
Yes.
Whether it was willful or deliberate, that is a separate issue. But
Yes.
absence has been admitted.
Yes.
Fifth is that he was a scale 1 and a manager whose conduct should be impeccable and not indecent.
Yes.
These are your
And the absence which he's saying, the absence he has failed to. He has failed to prove his absence as a valid ground by corroboration. Even the documents relied upon.
There was no reasonable explanation of the absence. You have primarily harped upon that no permission was taken from me.
But the Lordship kindly appreciate the service regulation conduct. He is abide by the same. He has to follow that guideline. The guideline says you have to take permission from the authority or substantiate your absence. The argument which I have advanced before your Lordship and places the documents relied upon talks about that your Lordship, he failed to obtain a valid permission from the authorities. Not a single occasion, a period of 81 days, not a single occasion, he has obtained a leave in terms of the regulation. So he violated the regulations, which amounts to misconduct.
All right. What
In that
judgments
particular
your side? Any judgments you are placing?
Judgment, I am Lordship. Yes, I'm Lordship. The first judgment, 2015, Volume 2, SCC 610. There are multiples, Your Lordship, but I have shortlisted.
Yes,
And rest of the judgment relied upon by the division bench, I have also referred. But I will not trouble Your Lordship with all those multiple
Where
judgments.
do you have referred?
But I'm submission, I'm relying upon the observations made by the Honorable Single Bench, whereby we have placed multiple authorities of the Honorable Apex Courts.
Those judgments before the retour.
Yes.
Now, what
From
you have
there, I have shortlisted some of which are very important, so I am placing. So, Lordship, 2015, Volume 2, SCC 610.
page para?
Lordship, para 12 to 19. Lordship, the very first head, hailed, in the very first page, hailed. High Court in exercise of Article 226, 227 cannot venture into the reappreciation of evidence.
That is
That
well
is well said. Lordship, that is one.
Puna Shekaran.
That
Yes.
is one. The second authority, Your Lordship, 2011, Volume 10, SCC 249.
On the issue?
On the issue, Your Lordship, judicial review or validity. Judicial review or validity on the order of dismissal. High Court in exercise of its power under Article 220 head note B. Constitution does not act as an appellate authority.
Yes.
Once again. Lordship, 1996, Volume 7, SCC 509.
Yes.
Here the administrative tribunal trying to reappreciate the evidence on the same footing. If the administrative authorities has gone by the records, administrative tribunal cannot reappreciate the same.
This is identical.
Identical.
Thank you. Yes.
Yes. This is another. Well, 2009 volume 11 Supreme Court case is 678. So we have not malafidely so on, Your Lordship. Because senior friend was submitting before your lordship, lenient view may be taken by the honorable court with his undertaking. So lordship, take me amiss, I have obtained one judgment of the honorable apex court of this year, passed with 18th March 2025, where the honorable, the cyber copy, where the honorable apex court has held, court should not come to pass any judicial order on the ground of sympathy. Lordship, kindly page 8, para 18, internal page 7. अभी दे दीजिए कॉपी दे दीजिए अच्छा Lordship, para 18. The division bench in course of its interference with the order dismissing the writ petition failed to realize that in exercise of writ power under Article 226 of the Constitution, the High Court of the country do not come to aid of the tradie, the endowment, and the lethargic. The golden truth has to be borne in mind by all the courts exercising high prerogative jurisdiction. While mandamus will issue to reach injustice wherever found, it is equally true that exercise of discretion should not unnecessarily be covered by consideration of sympathy or grace or compensation or charity.
We are not on sympathy, we are on empathy.
Lordship,
That is why we are hearing you,
Lordship,
sir.
that is why, Lordship,
That is why we are hearing you.
do not take me MSA, Lordship, to counter
No.
it, kindly give him opportunity by giving an undertaking.
I will do our 25 to Supreme UC, Supreme Court judgment, wherein the court says that if there is a battle between the powerful and the powerless, court will tilt in favor of the powerless. Why? Because Article 38 of the Constitution is there.
Lordship.
It is a question of exercise of discretion. Discretion which you might exercise and I might exercise. The amplitude of the same may not be same. It cannot be same.
Obviously.
Because your discretion is dependent upon your intrinsic qualities. What surroundings you grew up, in what family you grew up, what were the moral and disciplinary traits taught to you by your family elders, what had been your legacy. These are all questions which constitutes your character.
Obviously.
The base level is that you have to be a good human being. If you are a good human being, in that case, your exercise of discretion will also be fair. But these arguments, there are, we can give you plethora of judgments. What does in accordance with law mean? A term which has no limits. In accordance with law, according to you, will be something, and in accordance with law, I will argue it to be something else. So the Grundnorm is your discretion. Now Supreme Court says that, see that he's suffering civil consequences, he's outside service. So you see whether natural justice has been complied with. But on the flip side of it, there are various judgments that natural justice cannot be taken to an unworkable limit. Cannot be taken. Otherwise, everything will become complex. And reason is the heartbeat of decision.
Obviously. So my submission, Lordship, do not take me kindly.
There has been modulation.
But what I am submitting before the Lordship.
When we used to practice civil revision motions, we used to do issue notice stay.
Yes.
This was your issue notice stay of the proceeding. No reason, no certain anything. Now the law has changed. No. Stay automatically will not do. One line explanation you have to give.
Yes.
Otherwise, your other higher court will.
But
matter of course. The argument was you are asking an explanation from a high court judge. I am in scene of the matter. I have seen, oh, this is the matter.
Respect, your lordship. The appellant before your lordship at the outset is a person who has no responsibility, no integrity, no good faith towards his institutions.
Now, responsibility we understand, but question of integrity does not come in.
Because he was not vigilant as well also. He
Yes.
was not responsible as well also.
His conduct was not proper.
Yes, he did not take care about the interest of the institutions.
No, what is your argument to that? His argument was that I have not committed any misconduct. I was protesting against the illegalities perpetrated by my superiors.
Yes.
Now, for that reason, he brought in an amendment to his earlier writ petition. Malafide allegations were incorporated.
Yes.
So, what is your answer to that?
The answer to that is that mere allegation or assertion won't serve the purpose. He simply, since he was proceeded against his misconduct, he come forward with an allegations against his official. He did not take any bother to corroborate the same. So how an institution takes such person back who is so irresponsible and is so arrogant? The allegation against his superior, save and accept mouthword, not a single scrap of paper. Possession of the have been different. He made a representation to the superiors against some of the officials.
All right.
But not a single scrap, bare allegation.
Yes, what reply you want to give? Thank you.
Lordship, with due respect, subject to your Lordship approval. Lordship, I do not burden with the judgment because already referred to by the Honorable Single Bench.
Yes, yes.
Lordship, I want to rely on the same. And if you Lordship, so it is.
We understood that.
I am not once again reiterating the same.
No, we have taken note of that.
Okay.
But I do not want to repeat that. Only thing is, I have handed over last occasion, millet.
Yes.
This regulation, Allahabad Officers Discipline and Appeal Regulation 1976.
Yes.
Second last page.
You were tried under conduct regulation.
Yes, ma'am. This is the misconduct under that regulation, and this is the procedure.
This has been referred to in the charge.
Yes.
Huh?
Yes.
Not page 84. Is discipline and appeal regulation referred to?
No, the charges under that regulation. Charges under the regulation of Employees Conduct Regulation 1976.
Punishment was under this.
Punishment under this. The penalties are under this, millet.
Punishment under, yes.
Now, millet, second last paragraph, second last page, millet. I have already made this submission only just to point out these authorities.
Second last page.
Page 23, the box.
Yes.
Can you see this? I am in scale 1 officer. Discipline Authority Assistant General Manager.
Yes.
Of the concerned zone. The zone in which I was transferred.
Where do we get zone?
But, because Assistant General Manager is always in respect of a particular zone. In Kolkata, there is Assistant General Manager of Kolkata zone. In Shiliguri, there is an Assistant General Manager of the Shiliguri zone. So, my contention last occasion I have submitted.
That it was without jurisdiction.
That's all. And second, so far Malapide past is concerned, I have shown to your lordship that the affidavit of opposition that they have filed, most of the paragraphs are not affirmed. That I have shown that, therefore, none of the allegations made in the writ petitions are denied. Only one thing I want to show Malafide from their affidavit. This I have missed. Let me just point out. page 373 of the paper book. Even the second transfer of posting was communicated by SME Finance. Now, let 373 is the letter
373.
373. These they have disclosed in their affidavit. The chart sheet contains that order of transfer was issued on 1st July. Order of transfer was issued on 1st July, which
Why did you say 376?
373.
370. This transfer, yes.
Now, chart sheet contains that order of transfer was issued on 1st July. The order of transfer that was communicated to me was of 1st July by SME Finance. And that order of transfer was issued according to them by the zonal office, the authority. Now, let kindly see 373. This was communicated and received by SME Finance on 4th July. Therefore, before any communication was made to the SME Finance, the order was transferred was issued by SME Finance.
No, he is the chief manager personnel.
Yes, and kindly see the stamp in the middle. Received 4th July by SME Finance.
This transfer order was issued on 1st July itself.
1st July.
This you ought to have taken in that writ petition.
No.
Where you challenge the transfer.
Yes, it was disclosed by in their affidavit in this proceedings. I was pleading malafide that SME Finance was acting malafide.
That is not an allegation here, Mr. Ahmed. That was in that writ petition.
Yes, that writ petition. Even in this writ petition, I have pleaded that. I have pleaded that in my pleadings. And to corroborate that, I have just
1st July 2016 chief manager পাঠাচ্ছে
SME Finance রিসিভ
না
করেছে
এটা চিফ ম্যানেজার অফ পার্সোনাল এটা কি এসএমই তেই this chief manager personnel is in SME division itself.
Yes.
The person who has issued chief manager personnel.
Yes.
So he SME interdepartmental. SME chief manager has sent it to SME assistant general manager.
No, let's
see heading. The letter was issued from Zonal Office, Kolkata Metro.
Zonal Office issues
under which SME Finance branch was working. The appropriate authority decided communicate this to Anupam Das. Thereafter, taking this communication from email as well as by post, since the decision was taken on 1st July, to corroborate this, the SME Finance Branch Assistant General Manager, by his letter, communicate the decision of the Zonal Office. This letter is of Zonal Office.
Yes. That's my point.
Zonal Office, Kolkata Metro.
That's my point.
Not of
the authority.
But the authority is obviously because the
come back to you.
Let's see.
Now show us the transfer order.
160. Zonal office is the appointing authority. Zonal office is the disciplinary authority. He is the authority who can transfer me. And this 373 is the zonal office who has issued the order of transfer on 1st July. And it was received by SME Finance on 4th July. 160 is the letter issued by SME Finance to me, which communicates the order of transfer.
Yes, communicates on that date itself.
On 1st July. On 1st July. That is prior to receiving the order from the zonal office.
No email communication was there. Maybe it was verbally communicated.
No, that is
received on 24.
That is the only communication that they have annexed. I don't know whether it was communicated through email or not.
If not communicated, how they would issue? Then there would have been a disciplinary proceeding against this assistant.
161. What is 161?
161.
It's a type copy.
This is similar to Anupam Das copy to zonal office. That is on 1st July.
ওই যে মেলটা পাঠিয়েছে
Well, this is a type copy, possibly. No.
No,
But this is the copy of the email, type copy of the email. And it was
So it was sent to you by mail.
sent to me mail on 1st July.
Right.
That I'm not disputing. What I'm saying that SME Finance received the order of transfer because it was issued by the zonal office. The zonal office issued it and it was received by SME Finance on 4th July. Therefore, the communication could not have been done before 4th July. That's my point. But that's all, blood. I think.
Achha, can you show us the penalties? What are the penalty provisions?
Yes. That penalties, there are minor and clause 4 of this regulation I have just handed over. Disciplinary appeal regulations, clause 4.
Yes.
Divided in two parts, minor penalties and major penalties. Oh, what did I miss? Only one thing I have missed. I'm sorry.
Page 97. Paragraph.
All the documents were produced by the presenting officer, not by the witness. 199. 199, last paragraph. First line. I had cited a judgment to demonstrate that documents needs to be
considered by
proved, but it was presented by the presenting officer, not proved.
Mr. Ahmed, how do he had been recalcitrant? how
But I have tried my level best, Milad. I understand.
now if a person is ultimately not willing to go to take up service,
Milad,
if a person says that
that's why Milad, I have cited judgment of 1998 that he has his dignity, which the court has considered in A.L. Kalra's judgment. That you being the boss cannot take away his dignity in a manner you want to. For that, you have to frame a discipline rules. And if you want to disqualify him, you have to do whatever you want to do in terms of that rules only. That's my point. And one of the submission was that this is disproportionate that is there.
all right, the learned advocates appearing for the respective parties have stated their arguments. Judgment is
Glad only one this letter you will also have shortfall on last occasion. This the first transfer order refers to a letter of mine, 29th March 2016.
Not a part of record, Your Lordship.
But this was part of writ petition,
Where you have failed to place.
not annexed.
Not annexed, how? Your Lordship? Because I don't have what is there. I do not
no,
have.
no, that is referred to where that is
But
referred
the
to.
rate petition, they have not annexed.
Page 155, first transfer order.
To the first floor. যে নিজের খবরটা খুলেছে নিজের খবরটা খুলে গেছে ও আচ্ছা আচ্ছা
Grateful to your Lordship for anything.
Only one. Last submission, taking the inquiry report has not been served upon.
Well, which one?
Inquiry report, what my landed significant has argued before the Lordship just now, on the last occasion, even
no,
addressed
that had been his argument first also,
Yes,
that there was no proper
inquiry,
service.
Inquiry report has not been served.
Hmm.
But page 222 of the order impugned records the inquiry report also sent returned with unclaimed.
No, it was sent when the
By
appeal
post.
when the statutory appeal was being heard.
Yes.
Then it was sent.
But before that, it was, yes.
By the order
Yes.
of appellate authority.
When?
By the order of appellate authority, it was directed.
Because when he took the point that there was no proper communication, appellate authority said that give him a copy.
But the fact remains, Your Lordship, I have already demonstrated, he reluctant to receive any of the proceedings.
Yes.
Your Lordship, so far as this letter is concerned, since he has not annexed, so my reciprocal submission court can do not take cognizance of this because I don't have occasion to deal with this.
Kalra, did you give it here?
Yes, ma'am.
Kalra you gave?
Yes, Kalla, I have referred that.
No, the compilation which.
Yes, I have referred.
All right.
Well, at 1998, Calcutta also records Kalla. আলাদাভাবেও আছে Should I hand over a copy of Kalla's?
না না এই রুলটা কোথায় গেল? কন্ডাক্ট রুলটা দিয়েছিল যে, কন্ডাক্ট রুলটা তো অ্যানেক্সড। হ্যাঁ তা আমারটা পাঠিয়ে দিও সাহেবের।
আইপ্যাডটা নিয়ে যেতে বলতে পারেন।
এই কিছু সকালবেলা একটা মাথা ঘুরছিলাম, এটা সেকশন 5 বানাবো। এই কার্তিক, এখানে এই কোনোটা কি আজকে জিজ্ঞেস করো কোন সাইজ আছে? Any matter both sides here?